quickly list pass over item number 7.
Wait, please. Yes, the petitioner is in this writ application is challenging the order in Annexure 6, by which the Central Administrative Tribunal has been pleased to reject the OA filed by him, challenging the decision of the government in stopping withholding of 5% of monthly pension for a period of 10 years. The I have given just a short note for your lordship's convenience. Please place the note. The petitioner in this writ petition assails the order dated 12/7/2019, possible and central. Which other side? May I pray that let it be any other day so that other council on the state. The Union of India is there. Union of India is also there. Who is to represent the?
Have they represented earlier?
Malas?
Earlier they have represented. Union of India has been represented.
I think so. As it appears that it has been listed at least on 3 to 4 occasions. Yeah, each bench it
Yes,
is
E.R.
getting
Verma and
listed.
Mr. J. Paul, respondent.
Just person so now Mr. Pari is to either he is to do it himself or engage one of the central government council to represent Union of India. Because one, two at least they are to be, then three of course you can do it. Four, all right. Okay, you just place it. Yes, let us. The petitioner in this petition assails the order dated 12/7/2019, possible and Central Administrative Tribunal in OA 260/97/2012, dismissing the application filed under Section 19 of the Administrative Tribunals Act and thereby confirming the order passed by the Disciplinary Authority under Annexure 1, dated 13/10/2011, by which penalty was imposed on the petitioner by withholding 5% of the monthly pension for a period of 10 years. 1998-99, petitioner was serving as Commissioner cum Secretary, Land Reforms at Cuttack. 27/6/2002, articles of charges were framed under Rule 8 of the All India Services Disciplinary and Appellate Rules, 1969, on the ground that while serving as Land Reforms Commissioner, Board of Revenue, Orissa, Cuttack, he passed illegal and irregular orders in favor of private parties in settlement revision case numbers 88/92, 101 of 92, 110 of 92, 113 of 92, 118 of 92, and 168 of 92, and thereby caused loss to the government in violation of Rule 3(1) of the AS Conduct Rules. 31/10/2002, the petitioner submitted his explanation. 14/11/2006, the inquiry officer submitted the report dated 19/5/2006, wherein he gave out a conclusion that there is nothing on record to show that the delinquent officer has passed any backdated orders and there is no material that he has been biased in favor of any private parties, and the judgments passed by him without being actuated by malafides cannot be said to be the malafide, and therefore not being in a position to assert that there was any lack of integrity or the delinquent was responsible for causing loss to the government and did not recommend for any punishment against him. 8/9/2009, the Disciplinary Authority, Special Secretary to the Government, did not agree with the report of the inquiry officer and called upon the petitioner to submit representation under Rule 9(2) of the All India Services Discipline and Appeal Rules. In the said letter, the disciplinary authority felt that awarding of punishment for stoppage of one annual increment with cumulative effect would be proportionate punishment. 14/10/2009, the petitioner submitted his reply. 30/4/2010, the petitioner retired from service. 13/10/2011, an order was passed by the disciplinary authority withholding 5% of the monthly pension for a period of 10 years. 7/2/2012, challenging the said decision dated 13/10/2011, the petitioner filed OA 260/97/2012 before the Central Administrative Tribunal. 12/7/2019, the judgment was delivered dismissing the OA by the Land Administrative Tribunal. These are the facts of the matter, my lord. Very, very short facts. The petitioner was a member in the Board of Revenue at Cuttack, and he has delivered some judgments. The allegations against him was that he has passed backdated orders, and by favoring the petitioners, he has caused prejudice to the government. He has given an explanation saying that he has not passed.
Favoring the parties, some of the parties. Okay.
In specific cases.
In specific cases.
6 cases they have given the list. In all those 6 cases, it is reported like that. And it was said, one more allegation was that he has suo moto picked up some cases to favor some of the private parties. And out of 6 cases, 1 case was not even a suo moto revision. It's a revision filed by a party. Whatever be, he has given some judgments of his according to his own wisdom. And since the charges were leveled against him that he has committed misconduct, reply was given. The inquiry officer conducted the inquiry, and he has called for the peshkar of the attached to him, and he did not turn up to establish the charge against the petitioner. Rather, he has made a statement saying that the succeeding LRC has pressurized him to make such allegations. Whatever be, then inquiring officer found that no malafide can be attributed to him.
Witnesses were examined.
Yes, some witnesses.
No, other than that Peskar, anybody else was the witness.
Yes, somebody else was
So
examined.
in any case, the inquiry did not
was
fetch
in my
any
favor.
result.
Yes, inquiry was in my favor, holding that no malafides can be
Who was the
attributed.
inquiry officer?
Inquiry officer is the additional secretary to the government.
Additional secretary. Is
Yes.
he senior to him by rank?
Just one second. Inquiry officer was at page 62. He is a member board of revenue.
Which was the inquiry report?
Inquiry officer, GA department.
Ah.
Deputy secretary to the government has given me the communicated the order to me. The inquiry officer is on GB Mukherjee.
Annexure A/C.
At page 62, you will also
62.
62. Inquiry report by GB Mukherjee, member board of revenue on the charges framed. He was also member board.
Member board of revenue. Yes, he can't be less than.
Right. He was also
Right.
member board. So he came to a finding that no malafide can be attributed, no backdated orders were passed. He called for the diary and found that no.
So ignoring the inquiry report, the authority on its own issued a so-called notice.
Yes.
Why 5% will not be deducted?
Now, why one increment?
One increment shall not be.
But finally, the order was that 5% of the. That was the notice.
So only that means if we ignore the inquiry report which has not supported the government, only on the basis of the notice, and there is no other thing.
There is no other thing, because the allegation is that I have committed the misconduct, because in 6 cases the judgments went in favor of the petitioners.
No, another thing, just let us say what is the principle of law? Suppose inquiry officer gives a finding in favor of a person, and the the disciplinary authority has every right to disagree.
Yes.
But and obviously he has to call for issue notice, and that has been done.
Done.
But what is the principle that what are the circumstances, or what is the situation in which you can disagree, and then it's not that at your whim and pleasure you can do it. When a inquiry has been conducted, unless there is something maleficeness in that particular inquiry, unless something has been not taken into consideration, some material piece of evidence, or the inquiry report is biased as such, if everything is okay, can there be on the proper on the part of the disciplinary authority to differ from it?
Yes.
And if it differ, what is the reason? Because we are to see that the reasons assigned by the authority in not relying upon differing, that must be is a good reasons must be there.
Yes.
That so what is that principle first? What is the principle, and whether that is available in the present case or not? So let us first see the reasons which has
Assigned
been
by the
assigned
authority
by
in
the
disagreeing with the
disciplinary authority.
Right.
At page 74, you will not.
70.
He has picked up some of the reasonings given by the inquiry officer and found that such reasoning, on the basis of such reasonings, it should not have been.
No, you please come to that 74.
74.
It should not have been exonerated.
The
74.
So it
Paragraph 3.
Paragraph 3, right?
Pursuant to the said advice of the UPSC and the DO and PNT, disciplinary authority has been pleased to decide to communicate its tentative reasons for disagreement with the findings of the inquiry officer dated 19/5/2006 as follows.
Okay.
Perusal of the report of the inquiry officer reveals that he has observed inter alia as follows in his report. The DO has routinely reopened cases decided by his predecessor without questioning why the petitioner, if aggrieved, had not gone to the appropriate court challenging the order. On the other hand, review petitions filed by the government council have been summarily rejected, but more importantly, earlier decisions have been reopened. This is one of the reasons in the inquiry report itself.
Yes.
The second reason is it is well settled that the same court cannot revise its own judgment passed on an earlier date unless there are mistakes of fact, clerical mistakes, or emergence of additional information that was not within the knowledge of the applicant when the earlier court was held. These mistakes have to be pointed out by the petitioner or by the court, and only then can the previous order be reopened. Conversely, in the absence of such instances, earlier judgments cannot be reversed. The pattern by which the DO has reopened earlier judgments is therefore questionable. This is the second reason of the inquiry officer. Third reason, the inquiring officer has observed that the DO, in emphasizing the history of settlement in Kulbani district, has to give an impression that it was up to him as a revisional court to give historic justice. In my opinion, this is the task of the government. As he himself has pointed out, no right or title can be given or extinguished under the OSS Act. Hence, reopening of judgments in the garb of review and deciding the rights and title is not a right given to him under the law. Next one, it could appear from the judgments that he has not given the due weightage to the submissions made by the government council. His orders rejecting the objections filed with the government council are stereotyped and are unsubstantiated. The other reason is no reason for rejecting in the case records the contention of the government council that the review petitions filed by the petitioner were time barred, or that permission under section 60 of the Kandhamal Regulation 1937 from a competent authority was not taken or given. The same degree of scrutiny was not applied to the petition.
So these are the reasons assigned by the inquiring officer,
Inquiry
right?
officer.
He has just quoted it from
Yes.
different paragraphs.
Yes, yes.
Okay, then what he has stated?
Then he has stated, although the inquiring officer's report contains the above observations, which clearly indicate the misconduct of the MOS, the inquiring officer observed as follows in the concluding part of his report. The Apex Court judgment of 1999, cited by the DO, while holding that a wrong interpretation of law cannot be a ground for misconduct, has also stated that, of course, it is a different matter altogether if it is deliberate and actuated by malafide. So, while a biased order against a government interest seems to be apparent and to that extent irregular, I am not in a position to assert that this speaks of a lack of integrity or the DO himself is responsible for causing loss to the government. The DO has acted as a court, and any procedural irregularity ought to have been challenged before the next higher authority. I therefore cannot recommend any punishment to the delinquent officer. In view of the inconsistencies in the observations of the inquiring officer, as indicated above, the disciplinary authority is of the view as follows. Perusal of the record shows that member of service had recalled and revised the orders of the predecessor in case number so and so under section 25 of the Orissa Survey and Settlement Act in usurpation of his jurisdiction and without following the provisions contained in section 5 of limitation law. It is a settled principle of law that the commissioner, when he exercises the powers of Board of Revenue and passes orders, those orders are treated as orders of the Board of Revenue and are not revisable on the principle that board cannot revise its own order. Besides, without invoking the provisions of section 5 of the Limitation Act and without receipt of any application from the parties for condonation of delay, the MOS allowed the revision which is vulnerable and cannot be sustained. In case numbers 88 by 92 and 110 by 92, the MOS passed orders relying on the unregistered sale deeds without verifying the genuineness of the same. In case number 88 by 92, he declared a sale deed void, which is beyond the power of the revisional authority. Further, the inferences drawn by the inquiring officer under paragraphs 11, 12, 13, 14, 15 of his report
Contradicts.
Contradicts. Disciplinary authority is in disagreement with the inquiring officer conclusions drawn under para 17 and 18 of his report dated so and so. In view of the above facts and circumstances, awarding punishment for stoppage of one annual increment with cumulative effect would be proportionate to the delinquency and meet the ends of justice. If you so like, may furnish a written representation. And for this, a reply was also given. The basic submission of mine will be, but if a judgment is delivered by an authority acting under the judicial, quasi-judicial authority or judicial authority, that judgment will be his own judgment. If it may go in favor of either of the parties. Therefore, merely because some judgments were delivered and it went against a party cannot be a ground for a disciplinary action. All the decisions, even taken note by the inquiry officer and disciplinary authority, also say that if some malafides are there, if some intention to pass such order is behind the delivery of judgment, certainly it will be misconduct. But cannot be said that because the judgment is wrong, it will be. But from the disciplinary authority's order calling upon the petitioner to show cause why punishment shall not be imposed after the inquiry officer's report, my submission will be is absent on that case. It says that some of the judgments he has passed wrongly or rightly, and therefore it's a misconduct. He is saying that. But ignoring the main principle involved in the case, that a judicial officer's order can be challenged in a higher forum if a party is aggrieved, and cannot be said that even if the order is wrong, it would call upon the disciplinary authority to impose punishment by a disciplinary action. What at best the basic finding is required to be seen is if those orders were tainted with any malafides.
Right. Suppose during course of passing of that orders, some irregularity has been committed. Let us say but some illegality has been committed. Let us say for condoning the delay, no application was filed under Limitation Act. He suo moto condoned the delay, whatever it may be. And those cases which he dealt that has already been disposed of, he suo moto called for. So maybe that it is irregularity or illegality maybe. Question is that what you are submitting, that would be challenged in the higher forum by the party aggrieved. But unless you show that he deliberately has done it to favor a party, there was some malafidness on his part to do the same, it cannot be said that
misconduct
is a misconduct.
Yes.
So irregularity and illegality not taking into account some provision of law or utilizing that provision illegally. So that is subject to challenge in the higher forum.
Yes.
But can it be said that it is a misconduct?
Right.
That is
that's exactly is the point.
No, but one thing is that whether any such situation was there where the court had to go for getting cases suo moto. Is it the only number of cases that the court had gone for the suo moto, or some other matters were also taken? Amongst them are these matters.
There are other matters also taken, but
basing on what? Is there any some kind of matter were taken up
petitions
like
were
that?
there. The finding that without filing an application for condonation of delay, it was it's not correct. In my explanation, I have said that the parties have filed a petition under Section 5 Limitation Act.
That is only to be seen, because I cannot have my own intuition that these cases are not proper and I have to suo moto get it.
Yes, but even if it is done, unless some mala fides are there with an intention to help some party,
mala fide will be seen from the conduct. It will be apparent on the conduct. Reason being, suppose 50 cases are there. All the 50 cases have not been reopened. And out of that, I picked and choose 5 cases. And I have reversed the order. That shows the mala fide.
My submission will be, he was posted in the matters related to Kandhamal district.
Yes.
Their registration act is not appealed.
Yes.
I'm just giving an example.
Yes.
The court says, the disciplinary authority says, he relied on an unregistered document without examining the genuineness of that. What further examination will be made?
No, that is part of
one of the reasons. Yes. Like that, he says that suo moto I have taken up the case. But I have given the specific instance saying that I have not done suo moto. In one case, 168, case number 168, there the party has filed a review. Finally, my submission was under Section 7(1) of the Board of Revenue Act. The Board of Revenue has got the power to review. Power to review. It's not that I don't have the power. While exercising as a Land Reforms Commissioner, I was discharging the functions of the Board of Revenue. So, if under the Board of Revenue Act, I have the authority to do it, and if I find some illegalities there or in the earlier order, then nothing prevents me in reviewing it. If you are aggrieved, the state can go appeal or challenge that order. That was open.
In review, we can reverse the order also. Or apparent mistakes are there.
Apparent mistakes are.
If apparent mistakes is there, or some matters which have been taken by the parties, but the court has overlooked, has not taken into account.
What within the scope of review?
Yes.
If I go to the extent of making
you just pointing out that there is a scope of
review.
Yes.
And what is the extent of review?
Section 7(1).
Which provision?
I have just quoted that. You will also kindly come to page 78.
78, okay.
Just about 10 to 12 lines above, Section 7(1) from the bottom.
Yes.
Section 7(1) of the Orissa Board of Revenue Act provides 7(1). The board may either on its own motion or on the application of any person aggrieved by an order of the board, review any order passed by itself and pass such orders in reference thereto as it thinks fit, provided that no order shall be varied or reversed unless notice has been given to the parties interested to appear and be heard in support of such order. So it is a review power, unlike Order 47. It is a review little wider. So board can review its own orders anytime passed earlier. But only rider is that parties should be given notice. It is not the case in any of the cases. The state was not heard. On the other hand, the allegation is that state was heard but not taken proper importance. The state submissions were given. But that is the very
Okay. So no order shall be varied or reversed unless
noted.
what you say that first of all the thing that the petitioner has so moto picked off those 5 to 6 cases. That is not correct in all these things.
Yes.
Even though he has power also, but it was made at the instance of the parties in
one case.
And so he has got power as per section 7. In addition to that, what you have submitted, that the parties have also been noticed. State was heard, but importance might not have been given to the submission made by the state.
In the opinion of the
that is what the opinion. So,
but in a case where a petition is allowed, it's obvious that other side will feel that importance was given to the submission of the petitioner, not to the other side. And that impression, that will not be misconduct. It may, as your lordships have rightly observed, there might be some irregularity or illegality. That was open to challenge. Always the state could have gone in against that order and could have said that this reopening of the case or review is wrong. Nobody prevented it. Admittedly, that was not done. Admittedly, the hearing was given to both parties. Therefore, in my explanation, I have said 7.1 gives this power. It is wider than Order 41 rules, Order 47 Rule 1. Otherwise, also.
What is the language in 47.1, sir? Let's go.
That where the error apparent on the face of record.
discovery of new and important matter or evidence which after the exercise of due diligence was not within the knowledge or could not be produced by him at the time when the decree was passed or order made, or on account of some mistake or error apparent on the face of the record, and for any other sufficient reason desires to obtain a review of the decree passed or the order made against him may apply so on. So, okay. So, this is actually, we just want to know if this, since 1, 2, 3, 4, 5, 6 cases are there. So, can you tell me that in which cases the judgment was pronounced on what date, and what is the reason for which he exercised the, or it was a plain and simple order? As you said that one case, in fact, the state or one of the party has filed an application. So what has actually happened in that? Means only one case that is there. In the other cases, he has just called for, or he may have given the reasons in the initial order that this is the reason why I want to exercise the so moto power. Then might have issued notice. So have you got that initial order after pronouncement of the judgment in each of those cases when he first exercised this so moto power?
Satisfying the court itself.
So whether those orders are available with you?
Readily.
So why not the records of those cases be called for? this case now.
That
The
revision cases.
revision case.
Yes. That will.
That would better we can see that. Let us say one judgment was passed 2 years back. Let us say, and he came across about that somebody has filed any application, and or he might have during course of the hearing of other matters, such an order has been, let us say, brought to the notice that you have passed this type of order, your predecessor. I mean, so he came to know about, and there is, I think, is there any period limitation that within this period you can exercise that power?
Section 7.1 doesn't give that. Section 7.1 of the Board of Revenue Act.
7.1 is not there, but here it is 30 days.
In the Limitation Act, it is not
30,
there.
30 days is there, sir, for review.
30 days for review is there.
Review is there.
Yes, but
so yes, who is to argue this case on behalf of Union of India?
I'm sorry, madam. I am appearing for the Union of India.
So
In our
this-
counter affidavit, we have already stated before the learned tribunal at page 88 of the writ application. Your Lordship kindly have a glance to paragraph number 1 and 2. There we have clearly stated that about the review, about the revision. Page 88 and page 89 of the brief. The query of your Lordship. The Revenue Court under the Orissa Servant Settlement Act is not a civil court.
you are reading in from page number 88.
My lord, my lord.
Okay.
Paragraph number 4,
Roman 1. Yes.
The Revenue Court under the Orissa Servant Settlement Act is not a civil court as supported by section 29 of the Orissa Servant Settlement Act 1958. Further, the proceedings settlement are summary in nature. No separate orders are there. Therefore, past on condonation of delay or detailed reasons given for decision. This is in keeping with the provision of Rule 3 of Orissa Servant Settlement Act, Rules 1962. There was no routine reopening of the cases of the predecessors as concluded by the IO. Out of 6 cases, SRP case number 168 of 98 was a revision filed before the Board of Revenue under the relevant section. 4 cases were recall orders as they were passed by his predecessors without any jurisdiction. As per Order 41, Rule 23 of CPC, the cases are to be remanded to the authority against whose orders the same have been filed. The revision cases come to the board against orders of the settlement order. Therefore, these can be remanded only to the settlement officer, not to the Tahsildar. One case was reopened as there was prima facie mistake of fact on the face of it, that is, private lands had been recorded in government khata. The power of Board of Revenue which he exercised included the power to review the orders passed by the Board of Revenue. It is binding upon the authority exercising the power of Board of Revenue to reconsider review when such appears. The Government Council filed no review but wanted to review of a review which is not permissible. Then paragraph number 3, settlement court is not a civil court as per section 2(9) of the Orissa Servant Settlement Act 1958. A revenue court means any court other than the civil court having jurisdiction under this act to entertain suits or other proceeding as per section 29 of the act. All authorities hearing an application, appeal or revision under any of the provision of this act shall do so as Revenue Code section 7(1) of Board of Revenue Act 1958 provides about review of an order by the Board of Revenue itself. This power extends to revision of previous orders. Further orders were passed for reopening the cases and reversing previous orders only after hearing the relevant parties as required by section 7(1) of the Board of Revenue Act 1951. The matter regarding reconsidering or not considering a review is a matter of the presiding officer of the court to decide after taking into account various facts, laws and submission. The observation of the disciplinary authority in the disagreement note are without any basis. The provision section 5 limitations were followed both in letter and spirit. Applications were duly filed by the petitioners and the Honorable High Court of Orissa has observed that in settlement cases, limitation has to be liberally viewed.
Just a minute.
Satisfied.
Yes, continue.
During settlement, limitation has to be liberal viewed. In one of these cases, it is observed that even after new settlement operations started, revision and review could be held. Genuineness of the unregistered sale deeds was never challenged by anyone, including the government council, nor doubted by the court. It is factually incorrect to say that a sale deed was declared void by the revisional court. There was no allegations in the imputation or any findings of the IO that a sale deed in case of 8292 was declared void. The representation submitted by the CO was duly considered by the state disciplinary authority. After taking into consideration of representation of the MOS and the comments of the Revenue and Disaster Management Department, therein the state DA was the following opinion. Order for remand is passed after setting aside the order passed in concluded proceedings. In the eye of law, it is not an interim order because the proceeding is no more remain alive. The powers of review do not extend to the extent of sitting over an order of reappraisal of all matters in order to differ with the final conclusion. As per the settled law, the power to recall a judgment cannot be exercised on such grounds which were available to be pleaded in the earlier proceeding and was not done, or where appropriate remedy in some other proceeding in challenging the said order was not availed of. The way the MOS has gone to review the orders of his predecessor clearly indicates that he has committed misconduct in discharge of his duties. Even assuming for a moment that he had jurisdiction, it is evident, as in the case of 82 by 92 and 110 by 92, that the orders have been passed by simply relying on the unregistered sale deeds without verifying their genuineness. And even in case of 88 and 92, the sale deed has been declared void, which again calls in question the very authority of the MOS was sitting while sitting in a
You are
review.
facing which section, Mr. Section 7, na?
7-1.
Page
7-1 of the Board of Revenue Act 1951.
Code of Revenue Act.
77, 78, page 78.
You should have given the name of the books which you are. Have you got that book with you?
No, I'm not.
And your lordship rightly held that your lordship pleased to call for the records, everything will.
No, that's all right. Which page you just pointed out that Rule 7 has been quoted?
78.
28.
Board of Revenue Act 1951. Orissa Board of Revenue Act 1951. से local year नहीं, local law रे. हाँ, कौन है उसमें? तो local law गुड़ा पर अच्छी. हाँ. Application of personal any order passed by itself and passed for product and provided that no order of such a carried or reverse unless notice has been given party of given every application on for a review. Any orders shall be made within 3 months from the date of the. That is the worry if the application is made. If if this is for the application of by party against, but own motion by किसी ये नहीं. Provided the board may not in any case extend such period, that means that is again for that application. But pro moto ପାଇଁ କିଛି period stipulate ନାହିଁ. So Mr. Bhukta, what Mr. Rao has pointed out by this placing this section 7 is that there is not total lack of power. The power is there. Section 7 of Odisha Board of Revenue Act 1951 clearly states that there is a power for review of any order. It may be so moto, it may be on the application by any party aggrieved. So what we find from this particular section, if it is on the basis of an application by any party aggrieved, then it is to be such application has to be made within 3 months. But if there is any delay, then it can be condoned for sufficient reason to be shown. But so far as so moto power is concerned, at least there is no time stipulated that you can only exercise your so moto power within this particular period. This is one aspect. Second aspect, let us say that he has got the power and there is some irregularity while exercising the power. Some provision of law should have been followed, some procedure should have been followed, that has not been followed. And let us stretch it to the extent that some illegality has been committed by overlooking some provision. But again, question comes that whether such irregularity or illegality, if the person has the power, so can it be said to be a misconduct on the part of that officer?
That has to be verified. Let me, because in
No,
this
what
case we
is
have
there
not
in the
filed.
order? Anything is there to that extent?
Yes, yes. In a tribunal's order, Your Lordship, I will see.
What is that?
Because many decisions when we deal with 482 application, we deal with revision petitions. Many time we find that some illegality has been committed in overlooking some provisions, or some provision has been wrongly applied, and something has been done, some evidence has been. So we find.
Yes, Your Lordship is right. Only on these 2 points. In this case, we have already not filed counter affidavit, I think. Counter affidavit, I think we have not filed.
No, here now there is no scope here to file any further counter affidavit.
Yes, yes, no counter affidavit because
you have already
tertiary
filed the
proceeding. Yes,
counter affidavit.
that stand we have taken before the tribunal.
That stand you cannot change your stand now. So we have to see whatever stand you have taken in your counter affidavit. The scope is very limited in a bit of certiorari. The scope is limited. You cannot take a new things. So whatever available, we have to see that whether the order is sustainable.
Only those 2 points. Let me verify, and Your Lordship may taken up.
But
can be disposed of.
We feel it necessary to call for the records of those cases that has not been done. That is
5 cases, madam.
5 or 6 cases.
6 cases.
6
number of those cases have been given.
Those numbers, my lord, given.
The writ petition you have given the numbers,
Yes,
Mr.
yes.
Please so that
82 by 92.
No, which let us.
Sir,
which page?
Page 30.
Page 30. Yes. 30 no?
8892.
ଏଗୁଡା କହୁଛି this case number is styled as settlement revision petition cases number so and so, right? So Mr.
4, 5, and 6.
Short case. So please come to page number 30. see in the middle portion, the case numbers have been mentioned. Settlement, revision, petition, so and so, so and so. So we want that you should produce these records. These are all disposed of matter, and those initial orders are not available with you. Okay. Because that record would speak many things, would be whether why he has exercised the so motor power. Number one, that what it says, that even if you exercise that, unless uh, the notice is given to the parties interested or they are hard in support of such order, the order cannot be varied. Here, as we find that we are told that the order has been varied, what the predecessor has passed, that has been varied. But question is that whether at least this mandatory provision that it requires the notice to the parties, that has been followed or not. If notice has been
Sufficient
issued,
opportunity has been given to the affected
if
parties.
notice has been issued, the party, and in spite of receipt of the notice, the party didn't turn off. So no fault lies with the person in adjudicating that matter. So for all these things, we feel it necessary that these records are to be perused.
Yes.
Some light is there.
Yeah.
Your last may call for those records. That's
Yeah.
right. At page 45, your last will have a just kindly look at it. So some reasonings are, while imputing charges, something has been said against each case.
45.
45. Regarding each case, SRP case number 88/92. First one.
Each case re eta kon diya hai
Charges charge more against what has happened in those cases.
Okay.
In this case, a revision case has been initiated and a petition filed by one Abdul Aziz, son of late so and so,
for correction of ROR. Leave those cases, etc.
On 1/11/98, the LRC Jagar Singh passed an order to carry.
No. An order was passed on 25/11/93.
In which the revision was remanded to the Tahsildar, Kandamal, to verify the details of the sale transaction to find out the entitlement of the petitioner.
Yes.
On 1/11/98, the LRC Jagar Singh passed
this present petitioner.
Yes, passed an order to carry out the previous orders, and accordingly the petitioner was directed to appear before the Tahsildar on 29/12/98 to produce his papers. But instead of mentioning the case number 88/92, LRC wrongly mentioned as case number 80/92 in his order dated 17/11/98. Therefore, on 16/12/98, he called for the file and observed that orders have been passed wrongly, and it should have been 88/92. He further passed an order issuing of notice to the party, fixing 12/1/99 for recall of the orders. On 19/1/99, the counsel for the petitioner was present and was heard. By a separate interpolation, it has been mentioned in the order dated 19/1/99 that the standing counsel was also present for the state. The final orders were passed on 9/3/99.
Interpolation was allowed. Acha, eta kon hai dekhiye pado. These are dekhi the baat eta. So that is why we the records are.
I am only saying that your lordships are right in trying to call for the records. That's why these observations.
This part, there is no. It is very relevant. Suppose inadvertently, in place of 88 of 1992, he has mentioned 80 of 1992. So it's a clerical error.
That is apparent on the face of record.
So let us call for it. During course of argument. Acha, लिख दिया. This is item number 7. Mr. S.S. Rao, learned senior advocate, filed the written note of submission on behalf of the petitioner, which is taken on record. Have you supplied a copy? to
I'll
Mr.
collect from my senior.
Mr. Das, you receive. Copy of the written note of submission has been supplied to the Mr. Orupanand Das, and additional government advocate. Mr. Deeptiranjan Gupta, Reliance Central Government Council, is present through virtual mode. Let a copy of the written note of submission be supplied to him also by Mr. Rao. During course of argument, the learned counsel for the petitioner submitted that perusal of the case records of 30 कैसे कर ले 30 है ना 30 पेज of settlement revision petition case numbers এটা page number 30 ରେ ଅଛି 80 by 88 by 92 comma 101 by 92 comma 110 by 92 113 by 92 118 by 92 and 162 sorry 168 by 92 be very much necessary. In view of such submission, let the additional government advocate produce the case records of the aforesaid 6 revision cases, settlement revision petition cases on the next date. Kebe rakhiba kuhantu, because these are old matters, so obviously because 92 matters mane oda ko dispose of heji, so let us keep it in the first week of December. Okay. आज ହେଲା 21 तारीख.
Second week of December.
Okay, second week of December. 11th. All right. Is this matter on the week commencing from 11th of December 2023. That a written note of submission is taken on record for the record. Free copy of the order.
Pardon me, Lord. Item 21. As per my instruction, my Lord, appellant is already.
No, there are some Passover matters. We are going serially. Why are you?
Item number 8.
You took time, Mr. Das. Priya is minor daughter of the petitioner is to be produced and hand over. Okay. And what is the last order passed? Or it is a fresh matter? No. Yeah, after 22/4/2021, it has not been listed. 22/4/2021 order number 10 पर आउ किसी order है नहीं. नहीं, अच्छा. So last date का order है standing council files the status report of the case that the investigation is still continuing. Now this is the status report dated 20/11. कौन अपन लिखिचंती कौन No, any progress relating to the tracing out of the victim यही नहीं किसी. अच्छा जो FIR जो दिया इतला सेटा कौन investigation से pending ही रही से accused किसी बेल मूव करनी है हाई कोर्ट रे कि
चेक
कोर्ट
कर ले वो तो I'll check it now.
हाँ तार ना देइछि तो accused ना FIR रे मैं unknown लिखिछि से पिला ना आपण जानिलेनी माने से
Accused person Dora Ranjan Bera.
कोड लिखछन कहले
You affidavit file it la.
हाँ
It was 5-10 days equation affidavit file.
Person Dora alias Ranjan Behra.
हाँ right right yes suspected person तो एठी सर्च कले जणा पड़ियो
Let me check.
you want
Some more
the
time.
some more time and so that IAC Tigiriya police station shall remain present on the next day.
With status report and all CDN.
But where is the counsel for the petitioner? B. Swai and A.K. Patnaik, whether he was present yesterday?
No, yesterday they were.
किए ना काली
Michael.
थिले तो काली थिले ଆମେ ତ କହିଲୁ ପାସପୋର୍ଟ କରି ରଖିଥିଲୁ ଏବଂ ଆଜି କୁହାହେଲା ଯେ ଆଜି ନିଆହବ ବୋଲି like non appears for the petitioner land counsel for the state has filed the status report dated 21/11/2023 of the IAC of Tirgiriya police station, from which it appears that steps are being taken for rescue of the victim girl. But till date, the victim could not be rescued, and even the suspected person, Dora alias Ranjan Behra, to whereabout could not be known. The status report is taken on record. The London Council for the state seeks some more time in view of submission made by the Land Council for the state lists this matter in the week commencing from 11th December of 11th December 2023. The inspector in charge of Tigiriya police station shall remain present on that day with up-to-date instruction. Free copy of the order be handed over to the London Council for the state. Yes.
Item number 11.
Mihir Shekhar Sahu. Okay.
I can leave more neatly. Time rescue.
Oh, rescue it. Look, non appears for the petitioner. So London Council for the state has produced a status report of IAC Mahanga police station dated 20/11/2023, from which it appears. Court election the okay. From which it appears that the victim girl has already been rescued and her statements have been recorded under section 161 as well as 164 CRPC. And
case has been
case has been
a mistake of fact.
Final report has been submitted. Now the mistake of fact. The status report is taken on record. In view of such report, no further order is required to be passed in this WPCRL, which is according to disposal. Yes. ଆଉ ତ କିଛି ନଥିଲା ୟା ଭିତରୁ। କାଲି କେତେ ନମ୍ବରଟା? କାଲି ଆମେ 19
21
Item 21 madam.
20ଟା କଣ ହେଲା? ଆଚ୍ଛା ହଁ yes କଣ ହେଲା 21?
Appellant is already dead madam. As per the instruction ଆମେ ଚିଠି କରିଥିଲୁ ଫେରି ଆସିଛି।
ଡେଟ୍ ବୋଲି କେମିତି ଜାଣିଲେ?
ସେ ସେଥିରେ
ଲେଖିଛନ୍ତି?
तो postal ये
Postal
remark,
ये
postal remark.
single appellant.
madam. हाँ।
Inna alias
Instruction.
Kamalakanto Malli.
Judgment तो देखिए हाँ single appellant. So Mr. Das, you are to obtain instruction on the submission which has been made. Okay, Mr. Siddheswar Mahanti, Land Counsel for the appellant, is present, and he submitted that when intimation was given to the sole appellant, Hina alias Kamalakanta Malik, about the date fixed for hearing of the criminal appeal by registered post later, it has been returned back with a report of the postal authority that the man has died. The appellant is dead.
Address is dead.
Huh?
Address is
the address is dead. The address is dead. The land counsel for the appellant produced the letter which is taken on recorded and let the learned additional government advocate obtain instruction from to the inspector in charge of Dhusuri police station as to whether the appellant is alive or dead. এটা হচ্ছে ভদ্রক জেলার তো এটা কাল আসন্তা সপ্তাহ রাখলে তো ହେଇଯିବ release this matter in the commencing from 28th November 2023 ଏଟାକୁ ତା ଭିତରେ ଯେମିତି ଥିଲା ସେମିତି ରଖିଦିଅ ହେଲା କରିକି
will come on my lord.
28 ତାରିଖରେ ଆସିବ ପରା କହିଲେ ହଁ ଭଦ୍ରକକୁ ଏଟା ଧୂସୁରୀ ଥାନାକୁ କହିଲେ ସେ ଯାଇକି ଦେଖିଦେଇ ଆସିବ written instruction be obtained for them from the IAC about yes. Yes, item 20. L. Mishra, Learned counsel for the appellant has been intimated over phone to collect the documents. However, documents yet to be collected.
He was supposed to file an application. The government supposed to file an application. Market even.
Achha.
It will be 161.
अच्छा सी मैटर टा सी जो डाइंग डिक्लेरेशन दैट इज
Prior to the during course of the copies of the exhibit ones also a 161 statement of the deceased recorded when vice he had supplied to them. Suitable I'm last order टा कोटा
5/10/2023 पर आउ किछि ऑर्डर हेछि देखलो
order to hit one for it if it is the same matter. Any?
No, Sita, I can.
This is not that matter. No, this is the matter. This is the
Hmm. Mr. Das,
No.
this is a matter of Mr. Tripathi was there on the other day.
Oh, yeah.
So during course of hearing, he said that the exhibit 1, so also the 161 statement of the deceased may be supplied to him. So we directed the registry to supply. Do not know whether it has been received or not, because the 161 of the deceased has been recorded. So law is well settled that that can also be treated as dying declaration. However, no step has been taken by the prosecution. So here now the question of taking of additional evidence under section 391 CRPC. So on behalf of the state, it is to be filed.
Mr. Mishra was there.
So there was a, so you are to file an application under 391 CRPC to mark that portion. So, but we have told you that please verify whether that person, that officer who has recorded their statement is alive or not, because he might have.
File that.
Huh?
He has to prove that.
Right. And if he's dead, if any other person competent to know that handwriting,
Signature of the
because again that is to be sent back to that person, to the concerned court. Or to concerned court if it is not, otherwise it is to be sent to the session judge at least to record the additional evidence. And of course, opportunity of cross-examination is to be afforded to the accused, because that will be utilized against him.
Yes.
So all these things are necessary. So we say that you think over the matter, whether you are to file an application or not. Now, what you have decided?
Send for instruction will get away.
Milord, I'm sorry, Milord. I'm busy. I'm extremely sorry, Milord.
Oh, it's all right.
Informants, I mean, the accused whereabouts are also not known to us. So we are searching for the accused also.
Both the things are necessary. Not only that IO whether he is alive or not. Number two, accused whereabouts, because if we send without knowing that, then accused will not be, it will not be possible to engage a counsel. So how he will cross-examine?
Because he has to be informed.
Right. So that is why before passing the order, because of that matter is of 2008 criminal appeal. So we wanted him to. You have already communicated to me.
I'll re-communicate today.
I have also, Milord, tried and also sent letter to his address to also ascertain.
Any response you have got?
No. So that's why I humbly requested.
The other day he was submitting that also.
To at least to help me, the State Council agency may find out.
No. What we say that before passing of the order, we want to be sure that some fruitful result would come. Otherwise, passing the order, allowing the 391 petition, if ultimately no result.
Correct, Milord.
I was already retired.
He was retired.
Now the whereabouts of the IO is to be find out.
No, he must be. If he is alive, he must be receiving pension.
Right.
That is not an issue.
He can come to the nearest court also, where from the video, it can be virtually, it can be recorded. That procedure is there, even if he is not in a position to come to the. So those things is not a problem. The problem is that mainly that
the accused has to be
accused, and if the IO is alive or not, that is to be also ascertained. So IO's name is there. If he has retired, so you can ascertain where he is staying, whether all these things. Right. Okay. All right. Had Mr. Il Mishra, learned counsel, appearing for the appellant, Mr. Sonok Misra and Additional Standing Counsel for the state. Have you received this Exhibit 1 and 161 statement?
Yes, my lord, that I have received.
No, that was to be supplied to both the parties. You have received that? All right.
Yes, your
Learned
lordship.
Counsel for both the parties submit that as per the order dated 5/10/2023, they have received the copies of Exhibit 1, so also 161 CRPC statement of the deceased recorded by the investigating officer on 22/10/2006. Mr. Misra and Additional Standing Counsel, however, submitted that communication has been made to ascertain whether the investigating officer is alive or not, but he has got some information that the whereabouts of the appellant is not known, and he seeks some further time to in that respect let the matter be listed in the week commencing 11 तारिखରେ ରଖୁଛି ଆପଣ ଦେଖନ୍ତୁ ये matter be listed on 11th of December 2023.
Again.
Learned Counsel for the state shall obtain specific instruction about the whereabouts of the appellant, ascertain the same, so also whether the investigating officer is available or not. Put up this matter on such and such date. Free copy of the order be handed over to the Learned Counsel for the state. Yes.
Grateful, obliged.
Go serially, just let us see that one. Sujit Kumar Gupta, this matter has been entrusted to him by the whether we have engaged him or he has been engaged. No, the court has engaged him. Sujit Kumar Gupta. Okay. So he is not present today, so the list engaged. Dear, list he is never attended. No. List about select for them. Mr. We are engaging Mr. Saugat Das. So you please intimate him. Okay. When the matter was called, this court had by the order dated 12/11/2008 engaged Mr. Sujit Kumar Gupta, the counsel for the appellant, is not present today since it's a jail criminal appeal of the year 2008 and ready for hearing. We engage Mr. Saugat Das. His name is appearing in serial number 37 in the list of Amais of High Court Legal Services. List furnished by the High Court Legal Services Committee, Orissa Cutter. The counsel for the appellant, the learned counsel for the state shall intimate the Mr. Das about his engagement in this case. He is not present. No? A copy of the paper will be supplied to Mr. Das by within 2 days କରିଦିଅନ୍ତୁ ଗୋଟେ ସପ୍ତାହ ଆମେ ତାକୁ ଦଉଛୁ so 4th ରେ ଆସୁ ହେଲା he will get about some time to prepare the case. Place this matter in the we commencing from 4th December 2023. The name of Mr. Das be reflected in the cause distance in place of Mr. Sujit Kumar Gupta.
Who is released?
Huh?
Who is released?
Yeah. So now this is item number 22. So okay. Next item.
23.
Satyanarayan Mishra. Huh?
I'm not that Satyanarayan.
No, you are number 4.
Yes, ma'am.
He is number 2. You
That
don't
number
know.
9 is
You have no idea. You should know who are the other 3.
So no. Acha, the first one that was appointed in 2008 is Aurobindo Tripathi. Then he did not appear. Then Satyanarayan Mishra was engaged on 4/3/2020. So now he is not present. So ऐसे list है list करो थोड़ा streamline कर दो लेकिन बड़े अच्छे ना लेवल.
My number is at 4, ma'am.
No, your number is 4. But you have good number of stocks with you. They are 20 years. 20 years.
He calls them secondary that I will allow the
Procedure.
maybe 10 years 80 का one.
नहीं इतना तो नहीं हमारे
ये एमन आसुचंती मिस्टर ये दीपक कुमार पंडा
गौरी रथा
गौरी कुमार रथो
Gurutha is coming.
2004 ये and Sasmita Devata Kaberi Mahanti Rita Singh ऐसे आसुचंती
Rita Singh Asuchi. Huh? Rita Asuchi. Kaberi Asuchi.
huh?
Kaberi Singh, Kaberi and Rita is coming also.
They are doing also criminal matter.
I'm doing but so for the life con.
मैंने live on this some list नहीं होगा.
we can't take chance.
So
Can I have that one list?
हाँ
Can I have?
you want to see that? अच्छा देखो suggest करूँ तो अपन there is no but because अन्य case इतने चौड़ी हुए life imprisonment case पड़ा तो cannot take it should be at least some experience in this.
You have 10 years and above.
Yes, ma'am.
by order dated 12/11/2018, this court first engaged Mr. Aurobindo Tripathi as the counsel for the appellant, and again on 4/3/2020, Satyanaran Mishra was engaged to argue the case, but none of them present in this court today. This appeal is of the baki sabu lekhi debe 2008 usual kar debe. Mr. Satyanaran Mishra bracket 4 is engaged as the counsel for the appellant, and his name be reflected in the cause list henceforth in place of Satyanaran Mishra and Mr. Aurobindo Tripathi. So paper book baki jaha guda ko onyo case रे अछि रखिन से 4 तारिख रे रखि देबे. So it will come on 4/12/2023. Next item.
24 मतलब संजीत कुमार दास अच्छी बस.
Yes. So এটা 24 याদের প্রথমে এনগেজ হইছিলে হরে কৃষ্ণ মল্লিক, তারপরে then J.R. Das,
Again, H. Malik.
no, H.
deleted.
Malik কইলে মো না
Deleted.
All right. সে দুইটা অর্ডার দেখিলে যে প্রথমে just write take down. It appears that on 22/12/2008, Mr. Hare Krishna Malik was engaged as the counsel for the appellant. And then on 17, J.R. Das can be filed wakalat na mana na.
Private.
On 13/5/2016, Mr. J.R. Das filed wakalatnama for the appellant, but none of the counsel is present today when the matter is called for hearing. Please give the name.
Sanjit Kumar Das.
DASH na kaun?
Yes.
DAS. Sanjit SNJIT. Sanjit Kumar Das DAS is engaged as the counsel for the appellant. His name shall be reflected. Baki jo se order actually name shall be reflected in the cause list and put in place of so and so. Hello. So paper book is to be supplied. Matter to be listed on 4th of December 2023. ସମସ୍ତଙ୍କୁ ଏଇ ଯୋଉ ଇଏ ନେବେ ଆମର ଅର୍ଡରରେ paper book receive କଲେ ବୋଲି endorsement ନେବେ. So Sanjit Das. Yes, next.
All right. 25.
Display board and देखो तो serial number. Yes. କେତେ ଥର engage ହେଇଥିବ
ये सब गुड़ा का पूरा ना गुड़ा उड़े थे.
हाँ
सब ना डिलीट कर. तो अनिमा कुमार देख
अनिमा दी
नहीं अनिमा कुमारी देख.
କେତେ ନମ୍ବର serial ଟା
सीरियल नंबर 7 ना.
ଆଚ୍ଛା ଏଇଟା ସେଇ ଟାଇପ ର ଦେଖିନି ଅନିମା ଦେଈଙ୍କ ନାଁ ତାଙ୍କୁ ଜଣେଇ ଦେବେ ଟିକେ
ମୁଁ ଜାଣେ.
ଆଉ ପେପର ବୁକ୍ ଆସି ରିସିଭ କରିଦେବେ ବୋଲି କହିବେ. ତ
4/1/12 करो.
4 ରହିବ ସବୁଗୁଡା 4 ରହିବ. ନେକ୍ସଟ
26.
56, my lord, we have tried a lot. We were unable to contact the appellant. My lord, the whereabouts we don't know about 26. My lord.
The last order was passed on 9/12/2013 when you are granted bail or what? This one, so one here.
He was on bail, my lord.
No, he was granted bail that time.
Yes, he was
Mr.
granted bail.
My lord.
And
2013 ପରଠୁ ଆପଣ client ଆଉ ଆପଣ
Not a single day he has contacted to. We have tried the person who had given that.
No. Why are you not like the other matter? Why are you not ଆପଣ ଯାହା କହୁଛନ୍ତି ବର୍ତ୍ତମାନ ମୌଖିକ କହୁଛନ୍ତି ନା ଆପଣ ଗୋଟେ ଚିଠି କାଇଁ ପଠଉନାହାନ୍ତି?
I have sent a letter.
Where is the what
I have posted postcard.
No.
postcard. ଆପଣ proof ରଖିବେ ନା ସିଏ ଆଣିକି ଦେଲେ ବର୍ତ୍ତମାନ ଗୋଟେ one of the land and council that the registered post ରେ ଦେଲେ ଆସିଲା ସିଆଡୁ dead bill.
On day after tomorrow I will send a registered post.
That should be done. So that
several times we have tried to.
You yourself appeared or you have been engaged by the legal aid court?
The appellant has engaged to my senior Mr. Patnaik.
It's all right, but it is now your responsibility. So it's a even though it was initially registered as JCRLA, but the moment you on her own he filed the wakalatnama, obviously the earlier engaged counsel by the legal aid board will not conduct the case. It is you who is to conduct
our
the case.
Responsibility.
So
one chance.
and you also take instruction, and Mr. Das you also take instruction. Mr. Tripathi,
we already sent.
कौन आसिला
आसिनी
केबे पठेजन माने आईएसी को कहीं छे
after releasing to our instruction, after releasing on bail, he once telephoned to my senior. Thereafter
that's all right. No, but that information is very much necessary. The Land and Council for the appellant submitted that even though communication has been made to the petitioner by sending letters regarding the date of hearing, but there is no response, and the whereabouts of the appellant is not known. The Land and Council for the state submitted that instruction has been sent to the inspector in charge. Who police station eda? Salepur. Yes. Of Salepur police station for ascertaining the whereabouts of the appellant on 13th of November on week on 20th of November 2023, and he may be given some time to ascertain the same. Put up this matter on 4th of December 2023. Yes. SHRI 12/2023. Yes, next.
My lord, in the meantime, I'll.
That is up to you. Just carry on. You need not mention it in the. Yes.
27.
Mr. Dilip Rai, SP Das. Yeah.
Dilip Rai अच्छे से I will inform. Next year होगा परिवर्तन पहला.
नहीं इंटरेस्टेड यदि ये कोई बना लो
मुझे इतना
पेपर बुक दिया ही नहीं. All right. So we are just not passing any order. You ask him. Yes, next.
Attach Mr. Patel is there.
Which one?
Attach. 28.
रिलीज ऑन प्रीमेच्योर मैटर से कोर्ट को डायरेक्शन देथिले कि कोन ग्राउंड रे करछन्ती आपन ओडे डिटेल दियंतु बोली ओडे कहै.
Any order was passed?
No. No. The district director supply paper book, argue the case before special bench. Special bench.
Okay, that letter is available. Letter of the Deputy Inspector General of Prisons is available. That so we wanted to know that, Mr. What we wanted to know the other day, suppose while releasing this prematurely, there would be a condition that it would be subject to so and so result of the. So what would happen in that case? So that is why we want to know. आपण जोटा produce करे ना ये letter सहित सेटा खाली जे एमानकु allow hela belly, but what is the condition in that? Because the provision says that if you do not comply, if you indulge in any criminal activities, the government has power to, appropriate government has power to revoke that. And suppose there would be a condition that it is subject to result of this one. So, but one, so that is why we exactly want to know that whether there is any such condition or not. Otherwise, premature release hegala. If he is not interested, matter ends there. But you should not forget that the conviction is still there. You have been released prematurely.
But conviction is there unless until it is.
Conviction remains. And important thing is that he has been engaged by the legal aid service. He cannot, without the consent of the party, suppose पक्ष लेखिकिनी ଦେଇଦବ ଯେ ନାଇଁ ମୁଁ premature release ହେଇଗଲି ମୁଁ ଆଉ appeal को proceed କରିବାକୁ ଚାହୁଁନି. Matter is different. But
so
moto he has been engaged by the legal aid services. So how can he do it? So for that, tracing out that man, number one, number two.
That he is now in native place staying, my lord. I am submitting report, I leave.
No, whether he is interested to pursue the matter
that I have not.
If he is not, we can dispose of the matter. If you will say that, no, I have been prematurely released, I don't want to. Matter ends there. So
I'll get it.
You have been engaged by the
yes, ma'am.
Legal aid or by the court?
No, legal aid, ma'am.
Okay.
My assistant Nilakantha Das.
No, who has been?
Nilakantha Das to engage ହେଇଛନ୍ତି.
ମୋ ଆମ ଗୋଟେ ଅଫିସ ଆମ
ଗୋଟେ ଅଫିସ ଅଛି. So no, it is office level ଆପଣଙ୍କୁ ଶୁଣନ୍ତୁ. ନୀଳକଣ୍ଠ ଦାସକୁ କୁହାଯାଇଥିଲା ତାପରେ ଆଉ ଗୋଟେ ଅର୍ଡର ହେଇଛି 4/3/20 ରେ ରାଜୀବ କୁମାର ମହନ୍ତଙ୍କୁ ଏନଗେଜ କରାଯାଇଛି ହେଲା. So
Rajiv Kumar Mahante was the last lawyer.
ହଁ ତେଣୁ ଆପଣ you cannot file even neither you nor this Rajiv Kumar Mahanta to whom court has engaged last time they have any authority to not face this jail criminal appeal. It's a 302 case like conviction either. Now if you have found out that person, Mr. So just get that whether he want. All right, it has been ଆଉ କିଛି order ହେଇନି ନା 4/3/20 last order ତ ଦେଖିଦେଲେ. Okay. It has been brought to the notice of this court by the learned counsel for the state by producing the letter of Deputy Inspector General of Prisons (bracket headquarters) dated 12/7/2022 that the appellant Mittu alias Ashok Kumar Swai has been released prematurely. आ नंबर टा केते कहले ए जो लोकडार ना केते नंबर सीरियल अछि
serial number 2
हां 2
हां ये जजमेंट है 2 मिट्टू alias
नाइ मिट्टू alias अशोक साई
ଆଜ୍ଞା
ନାଟା ଯୋଉ ସିରିୟଲି
ये जो ये दला था रिलीज हल्ला
ରିଲିଜ ହେଲା ତା ନମ୍ବରଟା କେତେ ନମ୍ବର ସିରିୟଲ ନମ୍ବର ମିଟୁ ଆଲିଆସ ହର୍ଷ ଗୋସ୍ୱାଇଁ ଯୋଉ
so
list
last sir 27
20 asha his name finds place as serial number 27 of the list supplied with the by the DIG of prisons. The Learning Council for the state today has produced the letter dated 12/10/2023 of the inspector in charge of Govindpur police station, wherein it is mentioned that it has been ascertained that the appellant is alive and staying in his native village. In view of the premature release of the appellant, the Learning Council for the state shall obtain instruction, written instruction from the appellant whether he is interested to pursue this jail criminal appeal or not. Matter be listed in the week commencing from 4th of December 2023. Free copy of the order be handed over to the Learning Council. ताडू लिखित नहीं आसीबे जदि ये थिबो नले जदि दस्तखत वाला थिबो टिप्पो चिन्ह वाला ताले एटा को टेकन ऑन रेकॉर्ड कर दियो हला यस नेक्स्ट केस
29
डी मित्र कोर्ट एंगेजमेंट को दीपाली महापात्र तो थिले 62 यस तापर दीपाली को जगह डी
मित्र लिखा
Dipali Mahaprabhu
the Mitra has already appeared for the appellant.
to which she has no objection. अच्छा जो she appear करिएले.
So D Mitra is the lawyer.
हाँ she अपन निजे तरफ को file करे D Mitra advocate अच्छा privately file करे सिर्फ okay.
Is he appearing in court?
Access to board.
No, he used to come, but he is basically a lawyer in the district court.
Yes.
D Mitra माना मुझे civil bar है civil. अच्छा अच्छा. हाँ. D Mitra.
Devasisi.
କହିବେ ତାଙ୍କୁ ନା କଣ କରିବେ କହିଦେବେ ଓକାଲନ ଦେଖିଛୁ ଓକାଲନ ଲେଖା ହେଇଛି ପୁରା ଫାଇଲ କଲେ କୋର୍ଟ ଏନଗେଜ କରିଥିଲେ ଦୀପାଳି ମହାପାତ୍ରଙ୍କୁ then when he filed the wakalatnama so ଏଟାକୁ ରଖୁଛୁ ଯଦି ନ କରିବେ ତାହେଲେ କାହାକୁ ଏନଗେଜ କରେଇଦେବେ ହେଲା ନେକ୍ସଟ ମ୍ୟାଟର ଡାକନ୍ତୁ 30 ଶାଶ୍ୱତ ପଟ୍ଟନାୟକ କଣ କୋର୍ଟ ଏନଗେଜ କରିଥିଲେ
Again, Sithre, Lordship may, I am appearing to VC, I may kindly be allowed to. Sithre, again, seta jail criminal appeal thila, tapore gote prisoner petition hi thila again. Prisoner petition.
ଆପଣ ତ ଓକାଲତନାମା ଫାଇଲ କରିଦେଲେ ନା
हाँ ମୋ power ଅଛି ଆଜ୍ଞା ସେଟା ମତେ ଆଜ୍ଞା
ନାଇଁ ଠିକ ଅଛି ତ you can argue there is
yes
no
I will argue ଶାଶ୍ୱତ ପଟ୍ଟନାୟକ madam ଆଜ୍ଞା
so you have received the paper book
no my lord that may be direct
get it paper book copy the Mr. L Mishra Land Council Ladikandra Mishra Land Council submit that he will argue the matter and the name of Mrs. Sashwat Patnaik, who is now the an additional government advocate, be deleted from the cause list. He further submit that he has not received the copy of the paper book. Let a copy of the paper book supplied to Mr. Mishra by tomorrow by the registry and the matter be listed. You can argue next week because there is nobody is coming, so release this matter on 28th. name of Ms. Ashok Patnaik shall not be reflected in the cause list. 28/11 କାହାକୁ ପଠେଇକିନି ନହେଲେ
ଆଜ୍ଞା ଆଜ୍ଞା ମୁଁ ପଠେଇକି ଆଜ୍ଞା ନେଇଯିବି ଆଜ୍ଞା
ସେଟା ଯଦି ସେ ଆସୋସିଏଟ କୁ ପଠେଇଦେବେ on behalf of Mr. ଇଏ କରିକି ରିସିଭ କରେଇଦେବ. Yes,
ଆଜ୍ଞା.
next matter.
Grateful Millard.
Manaswini Rao. Manaswini Rao engage ହେଇଥିଲେ 4/3/2020 ତା ପୂର୍ବ
Let me, I will inform madam. He is coming regularly. I will inform. ପଚାରିବି ତାକୁ ତ
ପରିବାର ଯଦି କରନ୍ତୁ ନହେଲେ ନାହିଁ ଅନ୍ୟ କାହାକୁ ଏନଗେଜ କରିଦିଆଯିବ.
ନାଇଁ ପଚାର ସେ was regularly coming to court madam.
Okay. We are not mentioning anything. ଏଇଟାକୁ ରଖା ହେଇଛି ଆମେ କୌଣସି ଅର୍ଡର ପାସ୍ କରୁନୁ ସେ ଯଦି କାଲି ଆସିବି କରିଦେବେ. Yes, next. ଦୀପାଳି ମହାପାତ୍ର ଏଥିରେ ଅଛନ୍ତି. ତାପରେ ଇଏ ନା କେମିତି ପଶିଲା SK ମଲ୍ଲିକ. এটা ଦୀପାଳି ମହାପାତ୍ର ନିଜେ ଓକାଲତନାମା ଫାଇଲ କଲେ consent ନେଇକିନି ପୁଣି ଯାହା previously engaged counsel without taking consent. Her name is there and in that list जोटा legal aid board
SK Malik
नहीं दीपाली महापात्र yes she has filed wakalatnama because SK Malik was perhaps engaged by this court
and she continued also till 11 15/11 बेल ହେଇଛି
हाँ 15/11 मिस महापात्र ना लिखा है ना बेल अलाउ
ना तो नहीं लिस्ट
हाँ ना item number 32 बरा
no not in the list she has filed Vinama
अच्छा एटा बस से फाइल करछंती
हां I'll inform
हाँ next matter रखो ये जेतिको मैटर लिस्ट है 2008 रो it was told to the registry that they just find out what are the left out cases of 2008 and list all those cases. So that is how they have listed. Now this is the response. Year wise finish करिया को अपनो चाहिए भी this is the problem. So
point 35 and 36 the J Katkia name may be deleted because his junior is doing that. He will do it madam. P Mahanti Pulokesh Mahanti 35 36
33 टा के कौन
33 टा का
गोपाल कृष्ण नायक ये तो रेगुलर प्रैक्टिशनर ना
थिला रेगुलर प्रैक्टिशनर कहि दउ तो थिला हम कहि
କରିବ ଗଲେ କୁଆଡେ ତାଙ୍କୁ କୁହନ୍ତୁ କାଲି 4 BK सिन्हा T सिन्हा माने तपस्विनी
T सिन्हा
सी तो करूछन
I'll inform.
Okay. Then 35 एमाने कोन एटा
35 36 से करिए पुलोकेश कोच
कटके नाटा कटि
हां नहीं सी जदी काली आसीबे तो सेटा तो जजमेंट रे हमें काटी दी परिबो बट लेट हिम कम दैट
he has come
के
Mr. Pulokesh Mante has come
yes So you have received the paper book in item number 35 and
Yes,
36.
Yes.
He's ready to.
You are ready?
Ready. Kali kariyo. Tomorrow.
All right. Then the last item of that jail criminal appeal is item number 37.
Prem Patnaik already.
Prem Patnaik dead. So is gala. Tapre
Appointment.
out appointment. Acha. So what about this Mr. D.P. Dhol, senior advocate? Punna Sahu, eta kon, eta regular appeal ta to?
Regular appeal ta sange achi out ko appeal to.
Huh?
मैं JCRL ले सांगे रखी.
हाँ JCRL sange.
हाँ CRL.
CRL.
No, it's all right. So if D.P. Dhol is to argue the matter, you are there.
Say I have for the two appellants, lordship.
No, it's all right. So you can also, Mr. Dhol is to argue this matter.
In the JCRL?
No. Criminal appeal.
Yes, lordship.
Mr. Dhol will argue.
Yes, lordship.
So let him argue also for Puna Sahu.
Both the.
You are already arguing the matter on behalf of two of the appellant. Another co-accused you argue?
So anybody is engaged in JCRL?
JCRL का प्रेम कुमार पन्ना ही बोल रहे हैं. ये उसी ना associate DP. हाँ मुझे DP दो. So please communicate your senior that he also, while preparing the case for the appellants in criminal appeal number 37 of 2009, you will also prepare for this Tuna Sahu in the jail criminal appeal. And we'll take up this matter either by tomorrow or day after tomorrow. Okay.
Day after tomorrow.
All right. So kali ki argument karibe kon? Aji to kote bhi hi parla. You argue. Ko matter argue karibe. I'm calling them so that they will also prepare na.
34 35 ta kariyo.
35 ta karibe. Yes. So 35 you get ready, Mr. Das. You also engage somebody or you are.
But I know information whether has a dead or Ali.
Last dead so intimation देखले ये बेल
yes बेल
35
बेल
214 हाँ 214 What is your instruction, Mr.?
Not this in my order.
He was granted bail, Mr. Das. He was granted bail by order dated 2/7/2014. So almost 9 years have passed in the meantime. 9 years more, some months have passed. So it is which police station?
Fulbani. Was 20 years.
20 years mane.
20 years got bail in 2014 only. Very much.
ଆଜି କମ୍ୟୁନିକେଟ କରୁନାହାନ୍ତି ସେ ବୁଲି ଆସିବେ କଣ ଅଛି ଫୁଲବାଣୀ ସଦର ଥାନାକୁ ଫୋନ କଲେ ଏ ଯାଇକିନି ଇନକ୍ୱାରି କରିଦେଇକିନି ରିପୋର୍ଟଟା ଦେଇଦବ so you get ready for tomorrow and we will take up this 2001 criminal appeals then because this is listed also 2001 ର criminal appeal these are all life convictions. ଆଉ ଆପଣଙ୍କର ଗଭର୍ଣ୍ଣମେଣ୍ଟ ଅପିଲ ଗୁଡାଏ ଲିଷ୍ଟ ହେଇଛି ମଧ୍ୟ ତ
33 କରିବାକୁ କହୁଛି ଗୋପାଳ 33 କାଲି କରିବାକୁ କହୁଛି ଗୋପାଳ
33
ଗୋପାଳ
ଏଇ ଯୋଉ ଆଇଟମ ଅଛି
33 ଟା ବି
33 ଟା ଗୋପାଳ ନାଙ୍କୁ ଇନଫର୍ମ କଲି ସେ କାଲି କରିବି କହୁଛି
33
yes ma'am
ହଁ ଠିକ ଅଛି
yes
ଓକେ ଗୁଡ୍ ଯିବା ଆଜି
Pattern to mention, let's see. Leftover matter item 77, weekly list. That is the acceptance of paperwork, my lord. Not fixed for hearing of case, my lord. That may be taken up, my lord. Only acceptance may be allowed, my lord. $77.
Okay, you want it to be added to the hearing list?
Yes, my lord. And paperwork may be accepted. The noting is there also. That is preferred by me, my lord, on the cost of my appellant.
All right. Item number 77, CRLA number 592 of 2007. 17. 4 sets of paper books have been filed by the learned counsel for the appellant, which has been verified by the registry and found to be in order. The paper books are accepted. Let a copy of the paper book be handed over to the learned counsel for the vigilance department. Matter be added to the hearing list in the week commencing from date making here. Yes.
Pardon to mention, my lord, weekly list item 158. My lord, the out of 10 years conviction, this present appellant is already 9 years, 9 months in custody, excluding the interim bail period. In that light, your lordship granted co-accused regular bail. My 158.
There are 2 matters in item
My
number
lord.
1. So which one you are mentioning?
I am mentioning for my lord 95 of 2015 CRL. And IA number is 2633.
So, Mr. Das, file टा मगे देखो तो कौन है?
Get the item.
Item 158.
158. Note करो.
Pardon me, my lord. Item number 63, my lord.
नहीं काली टा mention करते हुए
नहीं चिंता नहीं देखी दियों से जो कोई 10 वर्षरू कोण 9 वर्ष केते मास रही छंती.
Pardon me, my lord. Item number 63. Bail matter, my lord. Interim bail accused in custody 18/6/2020, my lord.
63,
my lord. On behalf of A. Das. Anyuddha Das.
Why are you mentioning it? It will be taken up when the matter reaches. Yes, next.
Pardon, lordship.
Pardon, out of list.
Lordship. Item password item 13, your lordship. Not press, your lordship. The appellant is acquitted from the learned trial court, your lordship.
13. The learned counsel for the appellant doesn't want to praise this CRLA on the ground that the appellant, after facing the trial, has been acquitted. In view of such submission, CRLA is disposed of as not pressed.
Oblige, lordship.
60. What is this criminal appeal for? Marker 62. 33 days. Yes, Mr.
Miller.
IA number so this is an application for condonation of delay. Stamp reporter has pointed out that there is delay of 33 days in filing this criminal appeal. After hearing the learned counsel for both the parties, going through the averments taken in the interim application, and since it's a case of conviction where the learned trial court has imposed sentence of 10 years, I'm inclined to condone the delay. Delay is condoned. IA is disposed of and admit. Call for the trial court record. You have filed any interim applications for bail, etc.? All right, leave it.
I mean, pardon, my lord, item 97.
Just. Yes.
Item 97, conviction is for 20 years. Out of that, he has remained in custody for more than 9 years. And in that case, I have also filed affidavit regarding the other cases pending against me. In all the cases, he has been acquitted.
Okay. We'll take up due course. Yes.
Item number 165, conviction is 22B. 165, my lord. 8 years, 1 month.
All right, you'll take an appeal.
Pardon, mention out of list, my lord. The appellant is custody more than 7 years, out of 10 years.
Give it.
My lord, while admitting the appeal, your lordship directed to issue warrant against the accused. But as per my instruction, the warrant was not issued till date. So,
We'll see that matter go list conference.
Item restoration of bail.
Item 111, my lord. I have filed IA 2489 of 23 for expedition of hearing, preparation of paper book, my lord, in our cost, my lord.
No, you prepare.
In a vigilance case.
It's all right. You prepare the paper book and file so that it will be verified, and if it is found to be in order, it will be accepted.
Yes, your lordship directed for direction. In our cost, we will.
IA number 2489 of 2023. This is an application for expeditious hearing of the criminal appeal. Learned counsel for the appellant submits that the appellant is ready and willing to prepare the paper book and file the same. In view of such submission, let the learned counsel for the appellant file the required number of paper books within 1 month. In the event of which registry shall verify the same, and if it is found to be in order, the same shall be placed for acceptance. Okay. Next.
52, 5-year sentence, my lord. Can you take it? Sentence is 5 years.
Which matter?
Item 52, my lord. Can you take it?
52, it has already been admitted.
Yes, ma'am. During trial, he was on bail and.
Just a minute. Judgment. So you are found guilty under section
376, type 11, and section 4 of the 10 of the POCSO Act, ma'am.
Not guilty under 31X.
Yes, so page 63, ma'am. But at the same time, the accused found guilty for committing the offense under section 376, 511, and section 10 of the POCSO Act. And the sentence is, my lord, page 67.
5 years, 10,000 fine.
Yes, ma'am.
In default, to undergo so and so.
You are on bail or during trial. Judgment at page 15, that is mentioned.
Yes, Mr. Das. This is item number 52, IA number 1934 of 2023. The learned counsel for the petitioner submitted that the petitioner was taken into judicial custody in connection with this case on 10/11/2015, and he was directed to be released on bail on 18/5/2016. And after pronouncement of the judgment by the London Trial Court, he has been taken into judicial custody on 19/7/2023. And since the sentence imposed is only for 5 years, there is no chance of early hearing of the appeal in the near future, and balance of convenience is in its favor. Therefore, the bail application may be favorably considered. Land counsel for the state oppose the prayer for bail. Considering the submission made by the land counsel for the respective parties, the sentence imposed by the London trial court, period already undergone by the petitioner in judicial custody, absence of any chance of early hearing, I am inclined to release the petitioner on bail, stay realization of fine. Yes.
115. 10 years conviction. The brain apparatus was also on bail.
110.
115, 105.
Huh.
965 of 2020.
10 years.
10 years.
What period you have remained?
So, so 300, 1 day, about 1 year.
Then you remain or will hear when in due course, yes, call for the matters. Who jaitla? Supplementary ଅଛି? that one.
Supplementary list item number 3.
Item number 3 कौन रखिला? Oh, अच्छा.
Lordship had directed the personal appearance to virtual mode.
Just let me see that order. Land counsel for the appellant submitted that when the appellants approached this court last time for bail in 2 different cells and were disposed of by a common order, and while rejecting the application, the appellant were given liberty to renew the prayer for bail after examination of the victim in the trial court. It is further submitted that since material objection C report are not available with the trial court, there is delay in framing charge. Okay. The London trial court has directed to supply the copy of the rejection order to the London special public prosecutor as well as the IO to do the needful in producing the C report and the material objects within. And since 2 months have passed, date of some C report as well as not. So what has happened? C report, what happened?
Lordship, in fact, what has happened is Lordship had called for the personal appearance of the director of RFSL. Lords, that post is lying vacant.
It's all right. Anybody from the
acting director, unfortunately, has some personal bereavement, so he could not appear.
No, you have not obtained. You could not obtain instruction whether the C report has been prepared or not.
Lordship,
I have not personal. I don't want to see the face of the. I want that whether the C report has been prepared or not. If not, then why not? And if you prepared, then why it has not been sent to the court?
Lordship, the issue here is the original reports exhibits were sent to RFSL, but subsequently they have been sent to Bhubaneswar, Your Lordship, SFSL Bhubaneswar.
Yes.
Now they were not aware of the SFSL Bhubaneswar. They were not aware of the order of the trial court, Your Lordship. They got that knowledge after I sent the letter this last week, Your Lordship. Now they were not taking it on priority yet. They were taking it serially. Now that they're aware, they have assured that it will be done within the next 10 days, and within the next 10 days, we will submit the final CE report, Your Lordship. And the medical officer from RFSL Sambalpur is also present for any queries Your Lordship has.
No. This report is to be prepared. Now it is the state FSL who is to prepare that C report.
Yes, Your Lordship.
And you want 10 days time?
10 days time, my Lordship.
Okay, that is one aspect so far as C report is concerned. Then what about the material objects? Why it was not sent?
Because they have also been sent to the SFSL Bhubaneswar.
No, all the material objects were sent to there may be some of the material objects which may not require to be sent to the C report or for chemical examination. Or all the matter, what kind of material objects are there in this case, which were sent? What is the forwarding report of that? Yes, Mr. IAC. Unmute yourself. Please see the last portion of the charge sheet.
Lordship, I have it.
So perhaps it has been mentioned that the material objects were sent to Director RFSL Sambalpur.
Yes.
Then you say that it has been sent to SFSL.
Yes.
That's a one part. But whether all those material objects were sent or some of them are not required to be sent, and it has to be produced before the court.
No, additional exhibits have been received on 22/6/2022, Your Lordship.
ଯେତିକି ଆପଣଙ୍କର ସି ରିପୋର୍ଟସ୍ ପାଇଁ ପ୍ରିପାରେସନ୍ ପାଇଁ ପଠେଇଛନ୍ତି ତା ଛଡା ଆଉ କିଛି ମ୍ୟାଟେରିଆଲ ଅବଜେକ୍ଟସ୍ ଅଛି ନା ନାଇଁ ସେତିକି? ନହେଲେ ପୁଣି ସି ରିପୋର୍ଟ ଆସିଯାଉଥିବ ସେ ମ୍ୟାଟେରିଆଲ ଅବଜେକ୍ଟସ୍ ପାଇଁ ଟାଇମ Have you got that forwarding report with you?
Yes, I got it.
So, how many exhibits were sent for C report, preparation of the C report?
My lord, up to A to P.
A to P?
Oh, yes. 14, my lord.
14.
My lord.
So, obviously, after preparation of the report,
only the MO will be returned, my lord.
MO will be returned, and so who is to collect that?
My lord, the IH will collect from the RFS, SFS, my lord.
Yes.
So let the 10 days time be given. So I will inform the SFL and to send the letter to the IAC also to receive.
All right. What is the name of the IAC who is present? Is he able to hear me?
Hello, IAC. आपन नाटा कौन?
Is not audible.
आपन audible हो नहीं.
आगुरु पेस्ट करूना केमती?
There were some issues while joining also, Your Lordship.
Ask him then to just
telling the name.
All right, so and so persons to the order dated 14/11/2023. So and so the inspector in charge of Kundhi Gola police station is present. The Land and Council for the state submitted that initially the exhibits were sent for chemical examination to the director RFSL Sambalpur, but it was then sent to state FSL Rasulgarh Bhubaneswar, and within 10 days, and he has received instruction that within 10 days the C report will be prepared. In view of such submission made by the Land Council for the state, let the IIC Kundhegola police station receive the C report and also produce all the material objects sent for such examination and produce the same before the Land and Trial Court, that is Additional Session Judge Padmampur, in special GR case number 65 of 2021. matter be listed, you want 10 days time, so I'm keeping it to 4th of December. No, it will come on 5th of December 2023. List this matter on. You are to
let it be 7th, 6th or 7th.
All right, let it be on 6th of December 2023. Free copy of the order be handed over to the Land Council for the. So, two things are to do, not only to obtain the C report, but all those material objects to be collected and produced before the trial court. Okay. Thereafter, the next orders will be passed. Yes, next.
My lord,
Lordship,
one IA file, my lord, because of one appellant number 1, Umakanta Sahu, his health is not well, my lord, in jail custody.
Which is that IA?
IA number, my lord, 2597/2023, my lord.
That has been filed for which appellant?
Umakanta Sahu, my lord. Only for Umakanta Sahu.
So what instruction you have received so far as that interim application is?
May I only make a small prayer to in the previous item, your lordship?
Yeah.
That is, your lordship, IIC Guy Sealat, your lordship.
See, wrongly in another.
It's in item 22, my lordship.
Who
just SFL.
Item number 3 ta var karna.
Lordship had directed the appearance of the IO. I had informed the IO lordship. He told me on phone that he will not be able to join your lordship.
Achha, this is IAC Gaisilat police station.
My lordship. The lordship had directed the appearance of the investigating officer, your lordship.
Yes.
The lordship, I informed him and he said he would not be able to join your lordship.
Why? Who said that?
The investigating officer, your lordship. The IO, he has now been transferred, and because he stated that he is no longer in that jurisdiction, I insisted on his presence, but that is what he has stated, your lordship.
Okay. What is the name of that investigating officer?
Observe.
Now the IIC Gaisilat police station will collect the
lordship.
that will. So that order stands. So far as that your submission that IO did not respond, what is the name of the investigating officer? Tell me. He has been transferred.
He has been transferred. He is now DSP, your lordship. His name is Inspector Sudhakar Sahu.
Inspector
Sudhakar Sahu.
Sahu.
My lordship.
He is now posted as DSP.
DSP, I don't know the exact location, but in Badgad, your lordship. I'll take that instruction. I'll give it to my lordship.
Mr. Sonak Mishra Land Council for the petitioner submitted that even though an order was passed on 14/11/2023 asking him to intimate the IO to appear before this court through virtual mode today and to explain why the order of the Land Trial Court has not been carried out in producing the material objects and the C report before the Land Trial Court, which has caused delay in the commencement of the trial. Even though he has intimated the IO of this case, namely Inspector Sudhakar Sahu, who is now the DSP, so and so, Kotigar DSP se elected. Okay, but he कौन से कहले? कौन अपन कहले?
Stated because he could not join because of some personal problems.
But he expressed his unwillingness to appear before this court. The Director General of Police shall ensure the appearance of the said DSP Sudhakar Sahu before this court on kebe tarikh rakhile? On 6th of December 2023. and he shall file show cause as to why a proceeding under Contempt of Courts Act shall not be initiated against him for not following the instruction given by the this court on 14/11/2023. Free copy of the order be handed over to the London State Council for compliance. Yes.
My IA petition, my lord.
Yes. Have you taken instruction on this IA 2597 of 23? Say for interim bail on the ground of ailment of the appellant number 1, who is now in jail custody.
I'll take that instruction.
All right. IA number 2597 of 23. There is an application for interim bail on the ground of ailment of the appellant number 1, S.K.SAHOO. Learned counsel for the state seeks some further time to obtain instruction on the interim application. Place this matter also on 6th of December 23 for consideration. Yes.
Item number 1.
Yes.
I have filed an IA for correction of the order, my lord. And last page of the order, inadvertently, it has been typed as appellant petition number 4.
Which order? Which order?
IA number
15/11/23.
IA number, my lord.
Just a minute. Yes, 15/11/23. It is IA number 2550 of 23.
My lord.
What modification you want?
My lord, inadvertently typed as appellant petition number 4 on last page of the order, my lord.
No, Biswajit Roy.
My lord.
Biswajit Roy is
Appellant number 4.
4,
I am for Vikas Biswas, appellant number 6.
Mr. It's a typographical error. Look on IA number 2806 of 2023. There is an application for modification of the order dated 15/11/2023. Passed in IA number 2550 of 2023. The London Council for the petitioner submitted that while considering the bail application of the appellant petitioner number 6, namely Vikas Biswas, bail was allowed, but in the operative portion of the order, it has been inadvertently mentioned appellant-petitioner number 4, namely Biswajit Roy, and therefore the same may be corrected. No, yes, not only that, in 1, 2, 3, 4, 5, 6. In the 6th as well as 7th paragraph, in place of appellant petitioner number 6, it has been mentioned to be appellant number 4, namely Biswajit Roy. Same may be corrected. Land Council for the state has no objection. Considering the submission made by the Land Council for the respective parties, the order dated 15/11/2023, passed in IA number 550 of 2023, is modified to the extent that in paragraph number so and so, where appellant-petitioner number 4 has been mentioned and name has been mentioned to be Biswajit Roy, the same shall be read as appellant petitioner number 6, Vikas Biswas. The rest part of the order dated 15/11/2023 remains unaltered IA is disposed of.
Copy in course of.
Yes, copy.
Item number 2.
Item 2, if I begin, it will take some time and it won't end. Yesterday I was making a mention for item 29. It will take 2 minutes, my lords. Let that be taken up. Because this won't be completed even if I start.
What is this matter for?
It's a bail, my lords. Bail in appeal.
Okay. You want it to be taken up on some other day?
Yes.
All right. Mr. Devasis Pandal and Counsel for
There was a direction by your lordship also on the last occasion to the state to produce certain documents.
6 for an adjournment, list this matter on such and such date. Yes. Instruction filed by the Land Council for the state is taken on record. Yes.
Lords. Next Friday.
Yes, will come next. Yes, next.
Weekly list, item number 29.
Yes.
Lords, here on 10/10/2023, your lordship directed me to serve extra copies on the state for serving copies of the petition on the informant, my lords.
Yes,
last occasion when the matter was taken up, it has no instructions had been received regarding that. This is a case where a petition under 205 filed by a doctor, my lords, in government service has been rejected.
The notice has been made sufficient today, your lordship.
Okay, my lords. All right, we'll take up next week.
My lords, my difficulty is this, my lords.
Yes.
This special judge there is posting it every 3 days and asking me to appear. If your lordship will pass an interim order that I will not appear, or
query that order.
Or those orders are every 3 days the matter is being posted.
No. Query the order because the
Getting
order.
A copy also is difficult, my
No,
lords.
you are now.
Matter is now posted to today, my lords.
Yes. What happened today?
Today again a petition has been filed showing that the matter is pending before your lordship.
All right.
So he'll pass an order in the late hours.
Learned Council for the state submitted that the notice is being made. Notice has been served on the informant today in order to give some time to the informant to appear before this court through the Learning Council. The matter is matter be listed on 5th of December 2023. Since in this case the petitioner, the appellant is a government doctor.
Yes, sure.
Government doctor, and he has challenged. She has challenged the order dated 28/8/2023, passed in city case number 1064 of 2021, bracket special act under Annexure 1 in rejecting the petition filed under section 205 of CRPC in a case under section 341, 323 of the Indian Penal Code and 32BA of the SC/ST POA Act. Till next date, the Learned Trial Court shall not insist for personal appearance of the petitioner. Yes.
Urgent copy of today's order, my lords. May I please be uploaded?
Item number 30.
Mr. Tripathi.
My lord. Yes. Under SC/ST Act, my lord. So notice is issued by your lordship.
What happened? Notice
Lordship,
sufficient?
we have yet to receive the confirmation, my lord.
Two times, my lord, your lordship has urgent.
Which police station?
Jagannath Prasad.
Who jila there?
Baleshwar, your lordship.
When you have sent it?
କାହାକୁ ପଠେଇଛନ୍ତି ଦେଖନ୍ତୁ ଜଗନ୍ନାଥ ପ୍ରସାଦ ପଠେଇନାହିଁ ତ?
Letter has been issued on 16/11, your lordship.
Okay, 16/11 means recently it has been. All right, we are keeping it next week. Get it.
Lordship.
You have received the case diary.
Case diary also we are yet to receive.
My lord, I have last time.
302 case, na?
My lord, the matter was by your lordship has already granted co-accused person.
We'll see that, but that formalities is to be complied with.
সেই নম্বরটা ଦେଇଥିଲି ସେଇଥିରେ ଥିବ এই just 11
case diary টা ଗୋଟେ number ଦଉଛନ୍ତି verify କରିଦିଅ.
312
Yes, 312.
I have last time also given.
And counsel for the state seeks some more time to obtain instruction about the service of notice on the informant. This matter in the week commencing from 28th of November 2023. Yes.
Item 32.
Yeah. $33 पर गला 33 तो आगुटा जाइए वेरी नॉट फेस कर ले बड़ा.
Item 34.
Yes, Mr. Panda, Amulya Ratna Panda is not there. Pass over.
Fresh material.
Fresh matter. Bail matter. 7/11/23.
Yes, your lordship.
Since one of the offence is under section 3(2)(v) of the SC/ST POA Act, let an extra copy of the CRLA be served on the Land and Council for the state. बाकी usual order कर देगा 2 weeks पर पके देगा non appears करिएगा ना
Item 35.
Vijay, okay, you are there. At account पे आज ही रही थला
No, yesterday I did not have the inspection on the notice to the informant. Today I have received that notice has been sufficient since 14/11/23. Your Lordship.
You have received also the case diary.
Yes, Your Lordship. Case diary is there in a connected matter.
Okay. Yes, Mr. Pujari, it is your first application or earlier rejected?
First.
8/5/2023. What is the date of custody?
Date of custody is 4/8/21.
4/8/21, and you have never come to this court.
Well,
Okay. So let us verify.
census.
Ramogano Naik. And charge sheet submitted under section
363. 363, 364.
Yes.
Exactly.
Mr. Misra.
363, 364, 302,
302,
201, 379, 120B, 109, 506 related to section 34 IPC.
No SC/ST.
SC/ST, these persons belong to SC. He belongs to SC category. That is why that has not been. He has not been charged with that offense.
But charge sheet has been submitted. One of the offenses is 3 SC/ST.
Two sets. Two sets of accused persons.
One has not been charge sheeted under 3 SC because he is a member of. All right. So what is the name of the deceased?
Satyabrata Naik. Satyabrata Naik.
Date of occurrence?
1/8/2021 during the night interval.
1/8/2021.
2/8/21.
Okay. Eyewitnesses are there.
Eyewitnesses are there.
What is the name of the eyewitness? One eyewitness, just tell me.
Basanta. Basanta. Copy number 2.
Anand Naik, Lordship.
Anand
Naik is one of the.
Please read the statement.
At page 37, it is there.
You have given?
Yes, I have verified, Your Lordship, the statement.
Yeah,
The
37, just a minute.
Madam, the allegation.
Just a minute, let me. 37. Ananda, yes, what do you say?
No, the allegations against them, the only allegation is that no overt act against them has been pointed out by the witnesses, but that they were seen during cremation of the body, Your Lordship.
Yes.
When the body was cremated, he was present there along with other accused persons.
But so far as assault part is concerned,
Assault part has been credited to two other people, Your Lordship.
not the petitioner.
No, not the petitioner.
3 bail petitions. I have given 3 orders. Same position.
Which bail application?
I have given orders at pages 46.
46.
44, 43 starts from 43. All the 3 persons, they are in the same. This petitioner is in the same position as my lord.
Or the learned counsel for the appellant, learned counsel for the state. Learned counsel for the appellant submitted that the appellant is in judicial custody since 4/8/2021, and he has been charged under section so and so. The occurrence in question took place on 1/8/2021, and as per the statement of eyewitness Ananda Naik, the petition did not participate in the assault of the deceased Satyavrata Naik, but he was there at the time of cremation of the dead body, and therefore he may be liable under section 201 of the Indian Penal Code, which is bailable in nature. He further submits that some of the co-accused persons similarly situated have been released on bail by this court in CRL number so and so 43 onward, जो bail order would actually लिख देना. And therefore, on the ground of parity and equity, the bail application of the appellant may be favorably considered. Mr. Mishra, learned counsel for the state, after going through the evidence of the eyewitness, fairly submits that the overt act attributed against the appellant would come under section 201 of the Indian Penal Code. Considering the submission made by the learned counsel for the respective parties, nature of accusation against the petitioner, nature of overt act attributed against the petitioner as per the eyewitness account, release of the co-accused persons on bail, period of detention of the petitioner in judicial custody, appellant for the. I am inclined to release the appellant on bail allowed. Yes.
Item 22.
Mr. Jena.
Yeah.
Yes, Mr. Mishra.
Lordship, the Lordship had directed for the appearance through virtual mode of the AC Kundegal. He was there. Lordship may grant me a passover. He has perhaps disconnected.
Yes, next.
Item 28.
28, Mr. Anupam Das.
I am appearing. My power also
Yeah.
there. On the last.
Notice sufficient, Mr.
Sufficient.
Kebe.
You may just give me a moment. Lordship on 1411, Your Lordship.
Is it your first application?
Yes, my lords. This is the first bail application. He is in custody since 16/9/2022, my lords.
Just a minute. Yes, custody since
16/9/2022.
And you have been charge sheeted under section
302, 325 of SC/ST Act.
325V of SC/ST Act.
Yes, Lord.
Name of the deceased?
Vijay Kumar Behera, alias Babula.
Date of occurrence?
Date of occurrence is, my lords, 14th June 2022.
Eyewitnesses are there?
No eyewitnesses there, my lords. My lords, the FIR, the charge sheet, the complete investigation does not reveal a single assault from the appellant, my lords. There is no allegation, specific allegation against the appellant. It's just that the FIR, my lords, it says
Tell me, if there is no eyewitness,
yes, my lords.
then what are the circumstantial evidence against you?
The only circumstance, my lords, on 12th June 2022, this appellant was seen with this deceased, and on that basis he has been arrested. Last in theory basis re jehetu 12/6/2022 he was seen with the deceased. Now the occurrence took place on 14/6/2022, and my lords,
How do you say that it took place on 14? Because nobody has seen the occurrence.
No, nobody has seen, just on the basis of the inquest report. Inquest report reveals.
Inquest report is that when the dead body was found.
Yes, my lords.
So that cannot be said to be the date of occurrence. So yes, Mr. What is the materials?
Lords, he has made extrajudicial confession before two witnesses, Your Lordship. One is Gopinath Behra and one is K. Gangadhar Reddy. He has stated that they were their friends, the deceased and the accused. They used to take liquor together, and the deceased had taken 17,000 rupees on loan from the accused, Your Lordship. Now, since he was not returning that, one day after having some drinks with the deceased, he throttled his neck and killed him, Your Lordship. And after that, he has hidden the wearing apparels and the other parts of the deceased. Your Lordship, that is the
Dead body was found where?
Near Kali Dhaba.
So that was at the instance of the appellant it was recovered?
No, my lords.
No, Your Lordship.
Then it was lying on the open space or what?
Yes, my lord.
Any material recovered at the instance of the appellant under 27 of the Evidence Act?
No, my lords, there is nothing. It's just
Who has stated about the last scene?
there are several PW witnesses who has stated in their 161 statement that on 12/6/2022 we have seen both of them together.
And what is the PM report finding?
The PM report finding is, my lords, on 14th on 14th at around 10:30 or 10:45 the occurrence has been taken place. None of the witnesses has stated that on the date of occurrence they both are seen together. And last in theory is, my lords, settled that the occurrence and the both of the
Just a minute. When the postmortem was conducted?
That's on 14/6/2022 at 1:10.
And they were last seen on
12/6/2022.
At what time?
Lots of 12/6/2022 समय सकाळ 6:30 AM रे समय रे विजय कुमार बेहेरा और बाबुला एवं पालिया छत्रपुर 2 जण मिसी मद पिउथिले। 6:30 AM.
So, at what place they were seen and what place that dead body was lying? That was not that place where the dead body was lying.
The PW witnesses have stated they have seen them together near Palia Chhatrapur, and Chhatrapur ro Kali Dhaba nikatre tara dead body was there.
It was at a different place.
Yes, madam.
Kooti dead body milna?
Kali Dhaba near Kali Mandira.
So, Mr. Mishra, Lordship, 12/6/2022 जहाँ पढ़िले जे सकाळू सेमाने they were seen taking liquor together. तापरे आउ गोटे जगार से लोकटार डेड बॉडी मिलला. That was on 14/6/2022. And postmortem report रो finding आसुची जे ता डेथ हेची 18 to 24 घंटा भितरे. तान मैंने जदि पोस्टमार्टम रिपोर्ट हेची 1:10 रे ताले 13/10/2022 गोटे बेलकु से गोटे बाग ता परे मरीची. तेणु आपणकर 12/6/2022 सकाळ ठू 13 गोटाए पर्यंत sufficient gap रहुची. So there is possibility other persons coming in contact with the deceased. So how can you say that that is the circumstance which is itself? And what about the extrajudicial confession when those statements were made?
Lodge on
before police.
Before police on 16/6/2022.
And when he confessed the
7 on
गोपीनाथ बेहरार स्टेटमेंट कौन कहूची केते बेला आसी से कन्फेस कला?
Lordship, I'm just trying to.
Yes.
17/6. 17/6, your Lordship. That statement has also been made on 17/6.
Okay.
Wrongfully stated 16/6.
कौन ऊपर टी पढ़िले ऊपर कौन से स्टेटमेंट रा टिके आरंभ रु टिके पढ़ो.
मु आज 17/6/22 तारिख दिन मो निज काम छत्रपुर टाउन को जाऊा समय छत्रपुर थाना मकदमा संख्या 116 तदंत समय छत्रपुर थाना आईसी सत्य प्रधान सार से मकदमा संपुक्त मुदाला को आरेस्ट कर थाना को आनी से मत उक्त केस रे साक्षी रूप रही तदंत सहयोग करने मु कथार सहमति प्रकाश कर.
This is not the extrajudicial confession. It's a statement before police.
He was in custody at that time.
He was in custody, so
Yes.
Part the learned counsel for the petitioner, learned counsel for the state. The learned counsel for the petitioner submitted that the petitioner is in judicial custody since 16/9/2022. He has been charged sheeted under section 302 of the Indian Penal Code, 32B of the SC/ST POA Act. The occurrence in question took place on 14/6/2022 and there are no eyewitnesses to the occurrence. The only circumstance available on record is that the petitioner was last seen in the company of the deceased, the appellant. The appellant was last seen in the company of the deceased on 12/6/2022 early morning at about 6:30 AM. And the dead body of the deceased was found on 14/6/2022 near Kali temple. And in view of the nature of accusation against the petitioner, the bail application may be favorably considered. London Council for the State placed the post-mortem report, which indicates that the cause of death of the deceased was on account of constriction of neck by hand, bracketed throttling, and there are some external injuries noticed on the person of the deceased, Vijay Kumar Behera alias Babula. The Land Council further submits that in the presence of police, the appellant made confessional statement, and the motive behind the commission of the crime is that the deceased had taken loan of rupees 17,000 from the appellant, which he did not repay in spite of the repeated persuasion by the deceased. Considering the submission made by the London Council for the respective parties, the nature of accusation against the petitioner, absence of any direct evidence, nature of circumstantial evidence on record, period of detention of the petitioner in judicial custody, I am inclined to release the petitioner on bail allowed.
Obliged, my lord.
That's item 22.
Yes.
The IAC is there, Your Lord, on virtual mode.
Yes. Why I asked the IO to appear or the IAS to appear?
Lordship, may I see Lordship's order dated 17/10/23, Your Lordship, where Your Lordship had directed that the IIC to appear before the learned trial court on or before 31st October and to receive summons in respect of two witnesses.
Yes, Lipun Patro and Jai Krishna Patro, and ensure their attendance on the date fixed. So he had appeared before the court.
Yes, that part has been complied, and Your Lordship, summons has been issued with respect to Joy Krishna Patra.
Yes.
But the whereabouts of Lipun Patra, we're still not, he's in hiding or something.
No, has he received the two summons?
Yes, he has received two summons, Your Lordship.
Mr. IAC.
Sir, mic ta on karun. Mic ta off.
Unmute red color ta जोड़ुଛି. Unmute करियो कौन था? So what is your instruction? He has received the two summons.
Yes, yes.
So what about if whose whereabouts is not known?
Lipun Patra, Your Lordship.
What happened to the Joy Krishna Patra?
We have served the summons on him, Your Lordship.
Why he has not appeared? The direction was to ensure the attendance on the date fixed. बुझिगिन कुहंतु तो.
Hello?
Please ask him over mobile phone. Mobile phone नहीं phone. After argument is over, I will take up this matter. Hello?
Lordship.
Yes.
Maybe, pardon me, Lord, on behalf of Mr. Agarwal. Start करो. नहीं.
Mic adjust करूँ.
May I please your lordship? Yesterday, my lord, I was placing prayer of the election petitioner, prayer A, prayer B, and last part of prayer B. And I concluded my submission with respect to the last part of prayer B for a direction to direct for fresh election. Now, my lord, election petition. Yeah, I put the rules according. Before I go to prayer A relates to form 2B. Prayer B, first part of prayer B relates to form 26. Before I go to that, I would like to invite your lordship's kind attention to certain pleadings in the election petition.
Now you are focusing your argument on which part of the...
No, I will place before lordship about form 2B.
Form 2. So...
And before that,
yes,
I am placing certain pleadings
yes,
of the election petition.
that is in connection with that form 2B.
No.
Then?
Apart from that,
Okay.
Your lordship, I invite your lordship's kind attention to page 3 to 6 of the election petition.
Page 3.
Page 3.
Yes, I got it. Which particular line you want?
No. Under paragraph 1, he has given the schedule of general election.
Leave it that, yes. 2 also he has stated who are the candidates.
2 he has stated who are the candidates.
Right.
3 he has stated
who has secured how many votes.
No, the total number of total electors.
Yes.
How many votes have been pooled?
Right.
How many votes have gone under nota? How many votes have been rejected? What is the valid votes? And candidate-wise
right.
vote statement. I invite your lordship's kind attention to chapter 37 of the Orissa High Court rules. Take it down.
Chapter
37. Election cases. No, 37.
Orissa High Court rules.
My lord. पार्ट बी टा नहीं ମୁଁ ଖାଲି ପଢି ଦଉଛି ଆପଣଙ୍କୁ ମୁଁ ଦେଇଦେବି ପୁରୁଣା ବହିଟା ଦେଇଦେବି ଏଥିରେ rule 5 ରେ କହିଲା every election petition shall in addition to the contents prescribed by the act more particularly of the provisions of section 82-83 thereof contain information as the date of election which he has given and the dates date of election and the dates of the if there be more than one written candidate at the election and the dates of the elections are different the latter of the two dates and shall also show that the election petition is within the time. Everything he has stated. What I beg to submit before your lordship is the election petitioner is not required to place it in his pleading. The election petitioner is also duty bound to provide proof of the same, to accept before recording a judicial finding that all these materials pleaded are true. But you call for collegian. ସେଇଥିରେ election petitioner prayer C ରେ to call for all relevant election documents relating to the nomination of the respondent along with the affidavit in form 26 from the custody of the chief electoral roll. Page 20 ର last bottom 21 ରେ ବି ଅଳ୍ପ ଟିକେ ଅଛି. And all other relevant documents. Though there was a prayer to this effect, there was no action in terms of this prayer. ସେ ଆଉ ଏ ଡକୁମେଣ୍ଟ ଗୁଡାକ ମଗେଇକିରି ଯୋଉ ପ୍ରମାଣ କରିବା କଥା ସେଗୁଡା କିଛି କଲେନି. Rather we have done that. Now your lordship may kindly come prayer allegations with respect to form 2B are in paragraph 7A. The total pleadings of the election petitioner are from paragraph 7A to 7J.
Now you are focusing on Form 2B.
Form 2B.
Okay, the prayer is that to declare the respondent has not submitted his nomination paper in the prescribed Form 2B. Okay. So your case is that the form has been, the nomination paper has been filed in the prescribed form. That is your case.
Yes.
Now, how do they justify, or what they are pleading, and what evidence they have adduced
That
that
I
it
will
was
say.
not in the prescribed? Yes.
In order to see the date of notification of the election, your Lordship may kindly note Exhibit AE, that is dated 28/3/2019.
No, you are arguing on Form 2B.
Form 2B.
Yes.
I'm going to place that. If your Lordship will see Exhibit AG, Exhibit AH, Exhibit AJ, Exhibit AK, Exhibit AL, Exhibit AM. These are notices, statutory notices in Form 3A, Notice of Nominations. This will indicate to your Lordship that how many persons filed their nomination and how many sets of nominations were filed. I beg to submit that all total 11 members, candidates filed their nomination, and in aggregate 27 sets of nominations were filed.
Right.
During scrutiny of nomination, total 10 numbers of candidates were found valid. And kindly look to Form 4, that is Exhibit AA. That is list of validly nominated candidates. After withdrawal of candidature by one validly nominated candidate, total 9 people remained as contesting candidates.
Yes.
That will be available, withdrawal available habo Form 5, Exhibit AS3. Hela? AS by 3. Our list of contesting candidates available habo Form 7A, Exhibit AV. So far as the total number of electors are concerned, that is 2,35,699. Total number of votes pooled 1,33,854. Out of 1,33,854, total number of votes gone under nota 1,299 and 98, and 136 votes were rejected. So total number of valid votes were 1,32,420. This will be available to your Lordship in Exhibit DV, final result sheet in Form 20.
Yes.
Then, candidate-wise,
we have seen that is there in that paragraph.
Minor.
Those things are not disputed, Mr. Misra.
No, I am just
Yes.
ଏଇଟା ରଖିଦେଇଥିଲେ ନୋଟରେ ଆପଣଙ୍କ ଜଜମେଣ୍ଟ ବେଳକୁ that will be easier.
This is already been noted down that which paragraph.
Now, Exhibit DZ, Form 21E, return of election. Who candidate kete vote paila?
Okay.
If your lordship will go through it and compare the number of votes pulled by the election petitioner, which is 46,417, and number of votes pulled by the respondent is 50,244,
right,
and the margin of difference is 3,827. Now, on 3/7/2019, the present election petition was filed. On 14/10/22, on the basis of the respective pleadings of the parties, your lordship settled 38 issues. I am not placing
issues to work on.
Will I place issues?
No.
Not
I just.
Now, so far as allegations with respect to Form 2B are concerned, it is confined to page 6 to 8 of the election petition. Paragraph 7A.
Yes. No. What about that particular issue which relates to Form 2B? How many issues?
I will show that.
Because Form 2B ଉପରେ
ଯେତିକ issue
हाँ
ସେଇଟା ଦେଖିବେ
ଆପଣ ବର୍ତ୍ତମାନ ରିପ୍ଲାଏ ଦେବେ ନା ତାପରେ ଆର୍ଗୁମେଣ୍ଟ କରିବେ हाँ ସେ 2B ଉପରେ I think it starts from issue number 4 and 4, 5, 6, 7. These are the 4 issues, right?
ନାଇଁ ଆହୁରି ଅଛି
ଆଉ ଅଛି କି
8, 9, 10, 11, 12, 13, 14, 34 ଏଗୁଡାକ ଟିକେ ଟିପି ଦିଅନ୍ତୁ
ଟିକେ ଗୋଟେ ମିନିଟ
ମୁଁ ଗୋଟେ କରି
ଫର୍ମ 2B ଉପରେ ଯେତିକି
2B ଉପରେ ମୁଁ ଡାକି ଦଉଛି ଇସ୍ୟୁ ନମ୍ବର 4 5 6 7
yes
8 9 10
yes
11 12 13 14 34
okay.
So far as the pleadings with respect to Form 2B is concerned,
that is in paragraph number 7.
6 to 7A, 6 to 8. Page 6 to 8.
Election petition.
Paragraph 7A.
Paragraph 7A.
Page 6 to 8.
Page 6 to 8. Okay.
Our reply to the same is.
आपन written statement.
Again. Paragraph page 8 to 19.
Paragraph किधर?
Paragraph 23A.
23A page होची?
Page हबो 15 ରୁ 29.
15 ରୁ 29.
Okay.
ଏତିକି ପ୍ଲିଡିଂ ଆର ମ୍ୟାଟେରିଆଲ ଆଉ ଆଜି ଏତିକି ପ୍ଲିଡିଂ ମୁଁ ଆଗେ ପ୍ଲେସ୍ କରିବି. Mirror, I invite
So,
you.
no, just a minute, Mr. Misra, there is no dispute that so far as the candidate, each of the candidate, they are required to file the nomination paper in Form 2B.
There is no.
And that is prescribed, that form is prescribed in this book. What is that page just?
HBR ରେ ଆପଣ exhibit 3083 ବୋଧେ.
हाँ नहीं ମୁଁ ये ବହିଟା ସେଟା ଯିବି ମୁଁ ସେଟା ଲେଖିବି ଏ ଫର୍ମ 2B ଏଟା ଟିକେ ରୁହନ୍ତୁ ଫର୍ମ 2B 2G
If your lordship is holding universal,
এইটা
252
universal 252 না हाँ फॉर्म 253 ରେ ଅଛି ठीक है 253 So it is a prescribed form, and which particular section of the RP Act
33 and Rule 4.
Achha.
33(1) and Rule 4.
33(1) of the RP Act.
RP Act 1951
and Rule 4
of the Conduct of Elections 1961.
Okay. There are cases that the nomination paper filed by
Three
the
things. Three things. Basically, it is three things. I am placing whole of their pleading, and I will
just
categorize it. Summarize it. Page 6 किसे आगे देखो.
Now, before going to that, just few lines about the law. Just tell me, apprise me. Suppose it is found that it is not in consonance with Form 2B. Let us further. Then, in such a case, whether the that nomination paper is to be should have been rejected or not.
Yes.
So,
detergence. If it is not in exactly
yes
in form, your lordship may come to the conclusion that it is a defect in the Form 2B. ସେତିକିରେ ବି reject ମାନେ set aside ହବନି. Your lordship has to further hold, and the election petitioner has further plead and prove that the defect so pointed out by the election petitioner and found to be there in the nomination paper filed in Form 2B is a substantial.
Okay. That means ଏଠି ଯୋଉ ତାଙ୍କର କେସ୍ ହଉଛି ଯେ କେତେ ଗୁଡାକ ପାରାଗ୍ରାଫ ଓମିଟ କରିଦିଆ ହେଇଛି.
But ତାଙ୍କର allegation with respect to Form 2B is threefold. First is the respondent has not filed his nomination in prescribed Form 2B.
Right.
ସେଟା ଟିକେ ଖାଲି note କରିଦିଅ.
Hmm. Hmm.
Respondent Muhammad Mukim filed his nomination as Indian National Congress INC candidate for 90 Varavati Kotak Assembly constituency in the general election of the Legislative Assembly of the state. The appropriate form is Form 2B, appended to the Conduct of Election Rules 1961. The respondent filed his nomination paper before the returning officer on 2/4/2019, but the same is not in prescribed form. 2B. The respondent so moto deleted part 2.
That is number 2 aspect. So you said that one is the not filed in prescribed form 2B.
How it is not filed?
It
He
is
is
not
saying.
filed. Yes,
He is saying. One is
yes.
part 2. Respondent deleted part 2 of the form 2B.
Part 2 of deleted. Okay.
Second is part 3 of form B of the nomination paper filed by the respondent, also not in the prescribed form 2B.
Not in prescribed. Okay.
C rahela part 3A of the nomination paper filed by the respondent has not been filled up by the respondent.
Part 3A not filled up. Okay.
The columns of part 3A of the nomination paper has been left blank.
Left blank. Okay.
Columns from 3 to 9 are also not in prescribed form 2B.
Column, say part 3A or column?
Column 3 to 9.
3 to 9 of part 3A.
Are not also in prescribed form 2B.
Not in prescribed. Okay.
Chari rahla, it was incumbent upon the returning officer to reject the nomination paper.
That's obviously that.
But the returning officer illegally and improperly accepted the nomination paper of the respondent in contravention of section 33(1) of the RPR.
Properly accepted.
Read with Rule 4 of Conduct of Election Rules 1961. The returning officer should have rejected the nomination of respondent while exercising power under 36 of the RPR. Is not in prescribed form, as the nomination has not been filed in prescribed form. And E, the illegal improper acceptance of nomination of the respondent has materially affected the result of the election so far as it concerns the returned candidate. As such, the same is liable to be set aside. ଏତିକି ହେଉଛି ତାଙ୍କ pleading.
So, let us come to one by one. ଏଇଆ ତ ଆପଣ ପଢିଲେ ଆପଣଙ୍କର ହଁ ସେଇ ମୁଁ ସେଇଆ ହିଁ କହୁଛି ଆପଣ ଯୋଉ ପ୍ରଥମଟା କହିଲେ ମୁଁ ତାରି ଉପରେ ଆପଣଙ୍କର ଜବାବଟା ମାନେ ଆପଣ କହିଲେ ତାଙ୍କର ପ୍ରଥମ ଇଏଟା ଆସୁଛି ଯେ ପାର୍ଟ 2 ଟା ସେ ଡିଲିଟ କରିଦେଇଛି ଆପଣ ତାପରେ ଆପଣଙ୍କର
ମୋର ଜବାବଟା ହେଉଛି ପେଜ 15 ରୁ ପେଜ 29
ହଁ ସେଟା ମୁଁ ଲେଖି ସାରିଲିଣି ଆପଣଙ୍କର ରିପ୍ଲାଏ କଣ ପାର୍ଟ 2 ଡିଲିଟେଡ ଉପରେ page
the above allegations page 15 to 29
written statement bharatan
written statement
सेटा पेज नंबर कितने 15 हाँ ठीक है यस 15
paragraph
23 A I
खाली सही है गोटिए
हाँ 23 A रे तो अच्छी सब A small B एमटी
आज्ञा सब गुडा का तांका एलिगेशन रहछि तापर हमर रिप्लाईटा रहछि
हां नै ए पर्टिकुलर जिंसडा जो डिलीटेड ऊपर मु कन्फाइन कर देले सुविधा हो ए जो डिलीट करिवा ऊपर आपण कोन लिखि छथि ताकर केस होची बदे जेटा स्कोर करिवार थिला माने डिलीट टोटली काटिवार नथिला हां एटा होची ताकर केस
17 नंबर पेज रो लास्ट सब
17 नंबर पेज रो लास्ट
सब
पैराग्राफ अच्छा इट्स दैट इज
मुझे प्लेस कर दो
हां इट इज फर्दर humbly submitted पढ़ो
It is further humbly submitted by the sole respondent that while making above allegations, the election petitioner has admitted in his pleadings that the sole respondent filed his nomination as the official candidate set up by Indian National Congress. It is worthwhile to mention here that Indian National Congress is a national recognized political party as prescribed under Section 33 of the RP Act 1951. The nomination form is required to be signed by the candidate and by an elector of the constituency as a proposer. First proviso to subsection 1 of section 33 of the RP Act 1951 postulates that a candidate not set up by recognized political party shall not be deemed to be duly nominated for election for a constituency unless the nomination paper is subscribed by 10 proposers being electors of the constituency. A bare perusal of the Form 2B as prescribed under Rule 4 of the Conduct of Rules 1961, which is appended to said rules, it will be abundantly clear that Part 1 of the said form, this is material, that Part 1 of the said form is required to be used by candidates set up by recognized political party, whereas Part 2 is required to be used by candidates not set up by recognized political party. At the beginning of Form 2B, before Part 1, there is a clear instruction in capital letters that strike off Part 1 or Part 2 below, whichever is not applicable. Under the format of Part 1 of Form 2B, there is provision for proposing the names of candidates by one elector, proposer, and Part 1 is required to be signed by one proposer only, whereas its Part 2 there is provision for proposing the name of nomination by 10 electors as proposers to the candidature, and the Part 2 is required to be signed by 10 proposers. In the instant case, the sole respondent, who is admittedly a nominated candidate set up by a national recognized political party, Indian National Congress, is required under law to use fill up Part 1, Form 2B, which has been complied in letter and spirit in utter compliance with the provisions of law. On the other hand, the sole respondent is required under law to strike off the Part 2 of Form 2B, which has been done by deleting the Part 2 as prescribed under the law. It is only submitted by the sole respondent that word strike off and delete has one and the same meaning. This is the crux of my submission. If Part 2 of Form 2B would have not been deleted from the form, the same was to be struck off by the sole respondent. Hence, the defect pointed out by the election petitioner is not at all a defect of a substantial character. It is further only submitted by the sole respondent that subsection 4 of section 34 of the RP Act 1951, that the returning officer shall not reject any nomination paper on the ground of any defect which is not of a substantial character. Therefore, returning officer, while scrutinizing the nomination paper of the sole respondent, has rightly, properly, and legally accepted the same as valid and as prescribed under section 36 of the Act 1951. The further allegation, 2B ର ଯୋଉ deletion part part 2 ଟା part 3 ଉପରେ ବି ତାଙ୍କର allegation ଅଛି। ତାର reply ରେ ମୁଁ କହୁଛି the further allegation made by the election petitioner to the effect that the part 3 of form 2B of the nomination paper by the sole respondent is not also in the prescribed form 2B. Such allegation does not point out any mistake and or defect which appears under part 3 of form 2B. Se khali etiki कहछन, but he is required under law if it is not the same, then he has to state what is not there.
Okay.
It is only submitted by the sole respondent that part 3 of form 2B requires the candidate to declare that he is a citizen of India and has not acquired the citizenship of any foreign state or country. The respondent has provided both the things. The age of the candidate, that has also been provided. Name of the recognized political party setup, that has been provided. Symbols chosen by the candidate in unrecognized, this is not applicable to me. More jaha National Congress ro jo symbol mate seya milibo. That the name of the candidate and his father's name have been correctly spelled out in English language, that he is qualified and also not disqualified for being chosen to fill the seat in the Legislative Assembly, where applicable the details of his caste, tribe, and he has not been and shall not be nominated as a candidate. Eita am pai applicable no kana eta general seat. Present election from the more than 2 assembly constituencies. The election petitioner, while alleging that part 3 of form 2B is not in prescribed form 2B, has completely failed to plead and substantiate his allegations to the effect that the sole respondent has not furnished the required information and are not made correct and full declaration with respect to the above mentioned requirements. Similarly, the allegation made by the election petitioner with respect to part 3A of the form 2B filed by the sole respondent does not point out any particular mistake and or defect. It is only submitted by the sole respondent that part 3A of form 2B requires the candidate to disclose he has been convicted of any offence or offences under subsection 1 or for contravention of any law specified in subsection 2 of section 8 of the RP Act 1951, or has been convicted for any other offences for which he has been sentenced to imprisonment for 2 years or more, as to whether he holds any office of profit under central state government, as to whether he has been declared insolvent by any court, as to whether he is under allegiance or adherence to any foreign country, as to whether he has been disqualified under section 8A of the 1951 Act or by an order of the President, as to whether he was dismissed for corruption or for disloyalty while holding office under central state government, as to whether he has any subsisting contract with the government for supplying of goods or execution of the works, as to whether the candidate is a managing agent or manager or secretary of any company or corporation in the capital of which the central or state government has not less than 25% share, and last is as to whether he has been disqualified by the commission under section 10A of the 1951 Act.
Yes.
I have provided answer to all these 9 questions. The election petitioner, while alleging that part 3A of the nomination paper filled by the filed by the respondent has not been filled up by the respondent. Absolutely correct. False statement. The columns of part 3A of the nomination paper has been left blank, and columns from 3 to 9 are also not in the prescribed form 2B, has completely failed to plead that on account of such allegation the sole respondent has not furnished the required information as stated above. As such, is not qualified and or disqualified to contest the election in question.
No, ये जोटा कहिले 3A रो कॉलम नंबर 3 to 9 सेटा को आपण फिल अप करि नाहंती बेली से कहउछन 3
सेटा तीनटा जिंस
हां
first proof is my nomination itself. That has been exhibited. Original nomination has been exhibited.
Yes.
I will place that. Second is
yes.
What the petitioner himself says in cross examination. Third is the statutory authority to say whether these informations are there or not is the returning officer PW3. What is his evidence?
Okay. No, part 3A रो जो फॉर्म टा रहिला फॉर्म पार्ट 3A रो से जो तांगर एलिगेशन होची आपण जोटा लेखि जंदी 3 to 9 पर्यंत आपण फिल अप करि नांती बेली कहउछन
जे कहउछन करि जंती हमें कहउछु करिछु.
अच्छा ताले बेस्ट थिंग इज टू सी दैट
सर टिके आउ प्लीडिंग के जान तो पेज 28
हां
हम अधिका में छाड़ी देछु
first, second, third sub paragraph. It is pertinent to mention.
आपण कोड पढुछन कहले
28
टा बार को कोन 28
it is pertinent to third sub paragraph written statement
हां just 28 हां
it is pertinent to mention here that on 2/4/2019 the sole respondent has filed 4 sets of nomination in form 2B along with the accompanying documents before the returning officer giving therein full and complete information required to be furnished under the law. Those 4 sets of nominations have been duly received and numbered by the returning officer on 2/4/2019
as such and such leave it
as 2, 3, 4 and 5
right
respectively. On 5/4/2019 during the process of scrutiny of the nominations there was no objection raised against the nomination filed by the sole respondent. The returning officer, after being satisfied that the nominations filed by the sole respondent disclose all material and required informations, rightly and properly accepted all those 4 sets of nominations as valid. Therefore, the allegations of the election petitioner at a belated stage after being defeated in the election have been made with the ulterior political motive only to harass the sole respondent, and as such, the same are not worth accepting.
So, as it appears,
I have denied.
Okay, you have denied, and not only that, I think when the returning officer was examined, he said that I accepted it after verification, and I have rightly accepted it.
Rightly,
so that is. But when they say that this 3 to 9 of that form 3A is required to be filled up by,
and it has not been filled.
And he has not been. So the thing is that whether it is required to be filled up or not, and whether it has not been filled
up. There is no controversy that it is not required to be filled up.
Okay, so it is required to be filled up. And you mean to say that pleading made in the election petition that it has not been filled up is a false statement.
It is a false statement.
Okay, so
Best evidence is my nomination itself.
That is exhibit number
39, 40, 41 and 42.
39 ଟା ନାଇଁ ସେଠି ନାଇଁ you come to that exhibit
ଚାରିଟା ଯାକ ନେଇ ଆସ
ନାଇଁ ଏଇଠି ଅଛି ତ ସବୁ ହେଇଯାଇଛି exhibit petitioner ନାଇଁ exhibit 39 ପୁରା petitioner
ମୁଁ କହିବା କଥା with respect to these pleadings the relevant issues 12 issues ଟିକେ note କରିଦିଅନ୍ତୁ
exhibit 39 ଟା $39K. No. Wait. Wait a 40, 39 asla. No, yeah, next year 39 has. No, these are all annexures. That's a Bohiro. Leave that. You come to that exhibit 39 kind. Exhibit 33, 39. Now I got it.
Exhibit 39 is the original nomination.
Pailu 3A.
S2 believe ऊपर mark पर है.
Sir आगे 3 टा देखो ना.
3 टा.
3A से कोच में
3A टा आगे देखी दो.
ठीक है.
3A टा आपनकर
not filled up बेली तांगर कहला.
ଆପଣ ଲେଖା ହେଇଛି whether 3 ଟା ହଉଛି 3A ର 3 ଟା ହଉଛି whether the candidate has been declared insolvent by any court. ନାଇଁ ସେ ତ ତିନିଟାକୁ ଆମେ ସେ କହୁଛନ୍ତି 3 ରୁ 11 ପର୍ଯ୍ୟନ୍ତ ନାଇଁ ମ
ଟୋଟାଲି 3A କହୁଛନ୍ତି not filled up.
ଆଉଥରେ ଆସିଲେ ସେଟା ଯୋଉଟା ଆଉ ଗୋଟେ ପ୍ଲିଡିଂ ଟା ପଡିବ ମତେ କାହିଁ ଲାଗୁଛି ଯେ କହିଲେ ଯେ 3 ଠୁ
7 नंबर पे
प्लीडिंग दा इलेक्शन पिटिशन कर बैक करो
12 नंबर लाइन फ्रॉम द टॉप
टिक रोंद आपण इलेक्शन पिटिशन को आछन तो
आगा 7 नंबर
पेज को आछन
ऊपरू 12 लाइन टा बस
7 पेज नंबर 7 9 8 7 बस एटो को लाइन टा कहउजंती
नंबर लाइन
the part 3 of form 2B of the nomination paper filed by the respondent. 3A. अच्छा. 3A of the
nomination paper filed by the respondent has not been filled up by the respondent. First allegation.
अच्छा.
3A संपर्क.
हाँ.
Total 1 ରୁ 9 number column fill up ହେଇନି.
अच्छा. तापर कहउजंती the column.
The columns of part 3A of the nomination paper has been left blank. And column from 3 to 9 are also not in the prescribed form 2B. এই তিনটি কথা 3A
তা মানে 3 ଠୁ 9 ପର୍ଯ୍ୟନ୍ତ ସେ କହୁଛନ୍ତି ଏଇଟା ପ୍ରେସ୍କ୍ରାଇବ୍ଡ ଫର୍ମ ରେ ନୁହେଁ ଆଉ କେତେ ଗୁଡାକ କଲମ
କୌଣସି କଲମ ସେ ଫିଲ୍ ଅପ କରିନାହାନ୍ତି
ଅଲ୍ ଦି କଲମ ସେ କହୁନା ଦେଶ 10 अच्छा ठीक ଅଛି ନାଉ ସେଠିକି ପଳେଇ ଆସ ଯୋଉଟା ଏଇ ଯୋଉ ଏକ୍hitbit 39 ଯୋଉଟା so 3A रे I got it 3A.
So bottom देखंतु part 3A 1.
Whether the candidate has been convicted so and so yes no रे right मरचंदी अच्छा.
तापर जो कॉलम गुरा अछि if answer is yes.
सेटा दरकार नै.
2 नंबर पर्सन टिकट तळ बडू अछि.
Whether the candidate is holding any office or property no कहले. If yes ताले एटा पूर्ण करथांबो.
3 नंबर no कहले.
whether the 3 number no 4 नंबर नो 5 नंबर नो
6 नंबर नो
6 नंबर नो सब तो फिल अप होई छी ठीक से अच्छा से एमती कोना दी तो गोटे फिल अप होई छी अन्य गुडा को
सब गुडा हमें रखि छु पूरा
39 40 सब गुडा को फिल अप होई
रखि दो
just
that is why I said bring all the 4 sets of nominations.
No, that is here already that has been signed. 40টা দেখো। হ্যাঁ আমি দেখতে পাচ্ছি। ତାପରେ 39 ପରେ 40 କୁ ଆସିବା। 40 ଟା କ୍ଲିକ୍ କର, 40 ଟା କ୍ଲିକ୍ କର, ସେଇ 3A କୁ ଆସ। ହଁ 3 ରେ ଆସିଲା नो। आंसर yes ହେଇଥିଲେ ସେଇଟା fill up କରିଥାନ୍ତେ, ନାଇଁ। then 2 ଟା no, 3 no, 4 no, 5 no. Yes, it is good. Okay.
6 no.
हाँ देख सारिलेनी। 39 गला, 40 गला, then ଆଉ ଗୋଟେ କୋଉଟା ହେଲା 41 ଟା ବାହାର କର। ସେଇ 3A କୁ ଆସ। no ଯୋଉଟା ଦରକାର ନାହିଁ। ତାପରେ no, 2 3 no, 4 no, 5 no, 6 7 8 9 9 9। अच्छा 41 और लास्ट 42 में
42
42 रो 3A। अच्छा अच्छा वो एगुड़ाक नॉट एप्लीकेबल लिख दीजिए, माने एनए माने नॉट एप्लीकेबल।
आंसर इफ आंसर इज यस देन
हाँ
टू फिल अप।
अच्छा से एगुड़ा भी दरकार नथिला फिल अप, बट एनए लिख दीजिए नॉट एप्लीकेबल। एंड 2 टा लिखछन नो आ सेटा
3 4 5 नो लिखछन।
हां हां
6 7 8 9
मो आई अच्छा सी बोधे एई लाइट रे क्वेश्चन पचार थिले जे आपण जदि एग्जिबिट 41 रे 2 रे एकथा लिखि पारले नॉट एप्लीकेबल, then why have you not mentioned it in 39 40 and 41 that they have? हाँ will that I think that was the question put जे न करथांते तो सब थरे न करथांते। ए 42 टारे ताले काहेकी लेखिले एने एने अन्य गुडा करे काहे छाडिले।
But that doesn't justify their allegation nor prove their allegation. এটা হচ্ছে আমার
their allegation is that been not totally filled up.
Now when the it is clearly mentioned जे if the answer is yes, the candidate shall furnish the following information. So therefore it means that if the answer is no, the candidate is not required to furnish.
Even election petitioner in his election nomination paper also has left 2 columns blank. First item रो जो I2 XII अछि ता मध्ये आपण जतले एविडेंस देखिबे।
Okay. All right. So this obviously says that according to you that this averment which has been made in that election petition
with respect to form 2B
relating to part 3A, that
is absolutely false.
All right.
Now, my lord, with respect to form 2B, these issues are relevant. Your lordship may kindly take note of 4.
मते येटा कहले फॉर्म 2B ऊपरे जो गुडाक कहले इशू फ्रेम इज मु ताको नोटेड डाउन कर देली। 4 5 6 एवडा सब जो
ठीक है, खाली प्लेस कर देले
हमें कैटेगरी कल्लू कि
नहीं आपण कन्विंस है।
ठीक है ठीक।
4 हला whether striking
इशू बार करो
स्लैश डिलीशन ऑफ पार्ट 2
जस्ट a minute इशूज रो प्रथमटा बाहर करो रोमान
14-10 रो ऑर्डर अछि।
हां
14-10 से फ्लैग करते।
अच्छा अबडी तोड़ गणो। हाँ 4 नंबर टा हाँ ठीक है।
whether striking deletion of part 2 of his nomination in form 2B by the sole respondent in pursuance to the instruction given in the prescribed nomination form 2B renders the nomination of the sole respondent liable for rejection of his nomination or not. Whether the sole respondent has furnished all the required information in part 3 of nomination form 2B or not. Whether the sole respondent has furnished all the information as required in part 3A of nomination form 2B or not. Whether the alleged defects as pointed out by the election petitioner regarding part 2 of regarding deletion of part 2 of nomination form 2B as well as with respect to part 3 and part 3A of nomination form 2B do not constitute any substantial defect, and as such the nomination filed by the respondent is rightly accepted by the returning officer as prescribed under 36(4) of the 1951 Act or not. Whether the respondent filed his nomination paper in violation of section 33 of the RP Act 1951, whether the respondent has filed his nomination paper before the returning officer is in prescribed form 2B, whether part 3 of nomination paper 2B of nomination papers filed by the respondent is in prescribed form, duplication ହେଇଛି, whether the respondent has filled up part 3A of the nomination papers filed by him before the returning officer of 90 Baravati Kotak Assembly constituency as to whether column 9(3) to 9 of part 3A are in the prescribed form 2B, whether the nomination papers of the respondent was liable to be rejected by the returning officer as the same was not in prescribed form 2B, and as to whether the returning officer illegally and improperly accepted the nomination paper filed by the respondent in violation of section 33 of the RP Act, read with rule 4 of the conduct of election rules. 13. Whether the returning officer should have rejected the nomination paper in exercise of its power under section 36 of the RP Act 1951 at the time of scrutiny of nomination paper. Whether on account of alleged defects as pointed out by the election petitioner under paragraph 7A of the election petition, the result of the election in so far as it concerns the returned candidate, sole respondent has been materially affected or not, whether the returning officer has rightly and lawfully accepted the nomination of the sole respondent or not. 34th. Out of these, I think 12 issues, जो issue number 14 टा कहले, whether on account of the alleged defects as pointed out by the election under paragraph 7A, the election petition, the result of the election in so far as it concerns the returned candidate sole respondent has been materially affected or not. I will submit before your lordship, subject to what my learned brother says, that there is no evidence on this point.
Another thing, Mr. Mishra, ये जो आपण जो कॉलम गुड़ा को देखेरेनी पार्ट 3 ए रो जोड़ा से जो एग्जिबिट 39 40 41 40 हां 42 रो आई थिंक दे आर टेलिंग ये जो एठी लेखा आइची कॉलम 3 टा को मासची 3 ए रो 3 टा एटा सपोज लेखा आइची ए टाइप रो आपण बहिटा को टिके देखो
आगे बहिटा
हां बहिटा को देखंतु एवं ताकू सहित यो येटा को टिके धरंतु 39 टा को धरंतु जे कोनसी गोटे हेले व्हाट हैज बीन रिटन इन दिस number 3 रे whether the candidate has been declared insolvent by any court हैला ब्रैकेट रे अछि yes oblique no एवं ता तळे अछि if yes
सेकंड
अ,
लाइन डिलीट ही
हाँ जी हाँ यहीटाକୁ सी कहउछन्ती आपण डिलीट कर देजन आउ येस नो रे
बट
सी
दैट मस्ट बी स्पेसिफिक
हाँ
रीडिंग माय
जे
लॉर्ड এই লাইনটা ডিলিট করছন্তি আর ডিলিট করে আর ইফেক্টটা এয়া
এই
সেই ধরি নিয়া যাও ମୁଁ সেটা ডিলিট করে ଦେଇଛି ইটস এ ফ্যাক্ট দ্যাট আই হ্যাভ ডিলিটেড
সেকেন্ড লাইন ইট এস
yes
हाँ नहीं
Like
आपण
that
आपण
ଆପଣ
नो नो कला माने आउ सेटाକୁ
हाँ, ଯେମିତି
ପୂରଣ କରିବା ଦରକାର ନାହିଁ
ପୂରଣ କରିବା ଦରକାର ନାହିଁ କି ରହିବା ବି କିଛି ଦରକାର
ଯେମିତି
ନାହିଁ
1 ନମ୍ବର କଲମରେ କହିଲେ କି ପ୍ରଥମଟା ଏସ୍ ନୁହେଁ ବୋଲି ଏଗୁଡ଼ା ଫିଲ୍ଅପ୍ କରିବା କି ଦରକାର ନାହିଁ
ହୁଁ
ସେମିତି 2 3 ରୁ ଯୋଉ କଲମ ଅଛି
नो से कहउछन्ती
if answer is yes
नो से कहया कथा तांकर ये था हला जे आपण एई जो गुडाक
ଫର୍ମରୁ
तो
ଡିଲିଟ କରି ନଥାନ୍ତି
हाँ जेमती if the answer is yes the candidate shall तेणु आंसर एईटा को भी कारण आपण तोर नो ही गला ताले नो ही गले एतिक भी टोटल लेखिबार नथिला एगुडा भी डिलीट कर दी पारथांदे नंबर 1 रो जेतिक रोमान 1 रु रोमान 12 पर्यंत जेतिक कारण एगुडा तो आपणकर आंसर ही गला नो ना तेणु आपण एठी एतिक रखिले तेणु ताहले आपण 3 नंबर रे जेतु लेखा हिचे फॉर्म रे जे if yes has he been so and so but your answer is no you should have at least mentioned this माने किछि न पूरण करियार जस्टिफिकेशन नाही कारण आपण आंसर होची नो सेटा को डिलीट करिवार नथिला सी व्हाट दैट इज देयर केस
ସେଇଟା ତାଙ୍କ ପ୍ଲିଡିଂ ରେ ତ ନାହିଁ
नहीं माने जस्ट गोटे जनरली नहीं जाइछन
ଜେନେରାଲି ସିଏ କହିଥାନ୍ତେ ଆପଣ
हाँ।
ଯାହା କହୁଛନ୍ତି ଯେ ଯଦିଓ ସେ ଏଟାକୁ ପୂରଣ କରିଛନ୍ତି ନେକ୍ସଟ ସେଣ୍ଟେନ୍ସ ଟାକୁ ସେ ଡିଲିଟ କରିବାର ନଥିଲା
हाँ
ଏଇଟା କହିଥାନ୍ତେ କିନ୍ତୁ ସେ କହୁଛନ୍ତି ଯେ ପାର୍ଟ 3 ଟାକୁ ଡିଲିଟ କରିଦେଲି ବୋଲି
ଟୋଟାଲି ପୂରଣ ହେଇନି
ଟୋଟାଲି ପୂରଣ ହେଇନି ଆଉ ଡିଲିଟ କରିଦେଲି
that is why
their
you meant to say
pleading
that
must be
pleading
strictly
should be specific
yes
because that would give an opportunity to the other side to file his written
answer it.
statement okay
yes
even honorable apex court କହିଛନ୍ତି if it departure from the nomination paper pattern
हाँ माने substantial that is why the substantial nature हाँ किछि material information which is required to be furnished that has been suppressed or so and so which has effect because it would not come to the notice
on the election itself
it would not come in the to the notice of the electors then it should have been it can be treated as that it's a defect somebody suppose has the criminal cases he will so
part 3 रे जते अछि सब जाक रिक्वायरमेंट ऑफ लॉ सब जोटा नथिले जदि आंसर एस हबो the candidate will be debarred from contesting the election he will be disqualified
another thing suppose these are all the issues on that form 2B. So it can be all these issues can be taken together also answered in one big paragraph sub paragraph karigini it is not is it required that I should quote each of the issues not because gote form 2B upare jodi ette guda ko issue form heichi
their reply in composite our their proof in composite our reply in composite ତାଙ୍କର evidence ଆମ evidence returning officer ଙ୍କ evidence ସବୁକୁ together ନେଇକିରି ଆପଣ ଗୋଟେ କଲେ ସେଟା substantial ହବ
that would be the କାରଣ it is not necessary that form 2B ଉପରେ ପ୍ରତ୍ୟେକ issue
12ଟା issue କୁ ଅଲଗା ଅଲଗା answer କରିବା
that is it can be taken up together and it can be answered କାରଣ more or less ଗୋଟେ ତା आ संगरे connection ରହିଛି interlink ରହିଛି right okay so yes
we will continue
to right say time
I have a request ସେଇ 3ଟା ବେଳକୁ ରହିବ କାଲି କିନ୍ତୁ ଗୁରୁବାର ଶୁକ୍ରବାର I have a free office So kindly give me leave for.
We'll see tomorrow we can. Huh? Mr. Tomorrow is a hearing day, so it can be taken off at 2 o'clock. There is no problem. Today. अच्छा ସେମାନେ ନାଇଁ ନାଇଁ ଶୁଣ ଗୋଟେ କାମ କର ସେ ଯୋଉ
ନହେଲେ ମତେ ବି ଯଦି
ଯଦି ଅପେକ୍ଷା କରିବେ ନା ସେ ଯୋଉ ଆମର ଏଇ 3ଟା ବେଳେ ଥାଉ ଠିକ ଅଛି so ମାନେ ଭଲ କାଲିର ଆଜିର will be taken up at 2 o'clock ଏ ନୋଟିଂ ଟା ଦେଇଦିଅ ହେଲା ଯାହା କରିବ ତମେ କର ହେଲା ଠିକ
Lordship, item 22.
Is he able to?
No, Lordship. He's joined on another.
लिखी देबे
May I break leave my
yes argument continue करियो tomorrow रहला 3टा बेले हैना all right yes ता नाट आणले yes कौन होची मु किछि बुझी पान it will come tomorrow ask him to appear
My lordship.
Mr. It will be taken up tomorrow.
Lordship, should I ask him to come physically?
No. But ask him to come.
I will come at 10 o'clock and I'll.
तब correction गोटे 2 घंटा 2.5 घंटा हला से गोटे link ये करना दी बसचंदी then what is the purpose of providing them all these equipments?
Sir, नमस्कार sir, link रे अछि sir.
But you are not answering.
Sir, नमस्कार sir, अछि sir answer sir, link रे अछि sir.
So what is your name?
My name is sir Pavitra Kumar Sahu.
You are the IIC of?
Now I was posting sir Kondegula PS sir, Devot district.
Kondegula. So you must have received the copy of the order dated 17/10/2023. It has been communicated to you by the London State Council. And you are required to appear before the London Trial Court, that is Additional Session Judge cum Special Judge Devgarh.
Sir.
In that special GR case number 27 of 2017 on or before 31st October 2023 and receive summon in respect of 2 witnesses. One is Lipun Patra, the other is Jaykrishna Patra, and to ensure their attendance. So, आपण से ट्रायल कोर्ट रे हाजर हेइथिले आपण रिसीव करथिले समन
सर रिसीव करछु सर समन रिसीव करके सर एग्जीक्यूट करछु सर
दी जणक पई रिसीव करथिले
सर
तापरे कोन हला
सर से जयकृष्ण पात्र सर से दिन नथिला आ सी एक्चुअली सर रहू माने देखा हेछि सर देवगढ़ जिल्ला नीलबेरिन साही बोली गोटे जगह सेठी से नथिला ता घर पलसमा रे थिला सर से निजे रिसीव कला सर ताकू सर पपुन पात्र ना रे से रिसीव करछु सर तार नाटा एक्चुअली जयकृष्ण पात्र से रिसीव कला आउ ता भाई जे लिपुन पात्र सर से एठी रहू नथिला से समल रे रहउतला अनुगुल जिला सर सेटा भी सर्विस करिछु सर ता मिसेस को सर्विस कर देछु किंतु एबे खबर पाउछु जे लिपुन पात्र आउ जयकृष्ण पात्र 2 बार रे डेट अछि हमर कोर्ट रे अपियर करिया पैसा आ 2 बार रे से माने अपियर करिया बोली मु खबर पाउछु
नो
सेमान तो एग्जीक्यूट करा है
आपनको जेहेतु कुहाइथला केवल रिसीव करिकिनी समन कोर्ट रु तांको ऊपर सर्विस कर देले हबो नै आपन गोटे ता सहित एडिशनल थिंग कुहाइथला जे यू आर टू एन्श्योर देयर अटेंडेंस ऑन द डेट फिक्स से माने केमती आसी कोर्ट रे से दिन उपस्थित रहिबे साक्षी दबा पई से विषय रे मध्य आपन देखिबे तो आपन से विषय रे किछि स्टेप नेले नि खाली सर्विस कर दे पळाइले तो साक्षी आसी साक्षी तो ही पाइलानी
सर 2/12 रे अछि सर डेट
2/12 2/12 ଆପଣଙ୍କର ଦାୟିତ୍ୱ ହଉଛି ସେ ଦିଟା ସାକ୍ଷୀ ଯେମିତି ହେଲେ ଯେମିତି କୋର୍ଟ କୁ ଆସିବେ ଏବଂ ସାକ୍ଷୀ ଦେବେ।
सर
ଦେଖନ୍ତୁ ଦି ମିଷ୍ଟର ପବିତ୍ର କୁମାର ସାହୁ, the inspector in charge of Kundeigola police station, is present through virtual mode, and he submitted that he has received the copy of order dated 17/10/2023 from the Lannan State Council, appeared before the Lannan Trial Court, that is Additional Session Judge come Special Judge Devagad, in Special GR case number 27 of 2017, and also received summon in respect of witnesses Lipun Patra and Jaya Krishna Patra. And the summons on Jaya Krishna Patra was served in person, and Lipun Patra, who is the Lipun Patra which is Jaya Krishna Patra bhai,
sir,
who is the brother of Jaya Krishna Patra, was staying कोडी से समल रे थिला ना को
सर से समल रे नथिला सर एबे माने हमको खबर पाइली जे से पलसमा बोली गोटे गां अछि सर हमरे कुंढेगुळा रु 40 किलोमीटर खंड
लिपुन पात्र को जो समन टा कोन कले आकु तो देई देले
लिपुन पात्र समन ता मिसेस को दिया छै।
अच्छा, and it was served on the wife of Lipun Patra, and since it was told to them that they are to appear on the date fixed, he remained under an impression that they will appear, but in fact they did not appear, and now he has the next date of the trial is fixed to 2nd December 2023, and he will ensure the attendance of those two witnesses on the date fixed before the Lannan Trial Court. In view of the submission made by the IAC, the matter will be listed in the week commencing from 11th of December 2023. If the aforesaid two witnesses are examined, the Lannan Council for the appellant shall produce the certified copies of the deposition, their deposition, giving copies thereof on the Lannan Council for the state. Free copy of the order be handed over to the Lannan Council for the state. So ଆପଣଙ୍କର କହିବା ଅନୁଯାୟୀ 2 ତାରିଖରେ ଡିସେମ୍ବର 2023 ରେ ତାର ନେକ୍ସଟ ଟ୍ରାଏଲ ଡେଟ୍ ଅଛି, ତେଣୁ ଆପଣଙ୍କୁ ସେ ଲିପୁନ ପାତ୍ର ଆଉ ଜୟକୃଷ୍ଣ ପାତ୍ରଙ୍କୁ ଆଣିକିନି କୋର୍ଟରେ ସେମାନେ କେମିତି ଉପସ୍ଥିତ ରହିବେ ଏବଂ ସାକ୍ଷୀ ଦବା ପାଇଁ ଏ ବନ୍ଦୋବସ୍ତ ଆପଣ କରିବେ। ତାପରେ ନେକ୍ସଟ ଡେଟ୍ ରହିଲା, ଯଦି ସେ ୱିଟନେସ୍ ଦିଟାକ ହୁଅନ୍ତି ସାକ୍ଷୀ ଦିଅନ୍ତି ତାହେଲେ ସିଏ ଆଣିକିନି ତାର କପି କୋର୍ଟକୁ ଦେବେ। ତ ଏ କପି ଆପଣଙ୍କୁ ମୁଁ ଷ୍ଟେଟ୍ କାଉନସିଲକୁ ଦେଇ ଦେଇଛି, ସିଏ ଆପଣଙ୍କୁ କମ୍ୟୁନିକେଟ୍ କରିବେ, ତେଣୁ ସମସ୍ତ ପ୍ରକାର ବନ୍ଦୋବସ୍ତ ଆପଣ କରିବେ। ଓକେ
ନମସ୍କାର।
ଆଇ ମେ ପାରନ୍ ମାଇନର ଇଣ୍ଟରିମ୍ ବେଲ୍ ମେନସନ୍ କାଲି କରିଥିଲେ, ଆଜି ରଖିଥିଲେ।
ସେଟା କାଲି କି ଆସିବ। ଲେଫ୍ଟ ଓଭର ମ୍ୟାଟର୍ସ ଅଫ ୱିକଲି ଲିଷ୍ଟ ଡେଟେଡ so and so will be taken up tomorrow past।